The meeting will now come to order. Welcome to the August 6th, I believe, 2026 meeting of the City of Raleigh Design Review Commission. My name is Kyle Springer, and I'm the chair of the commission. The Design Review Commission is a public body appointed by City Council that exercises both advisory and quasi-judicial functions. The commission's responsibilities relate to zoning and other land use matters, as well as the visual and aesthetic characteristics of the city. First thing on our agenda this evening is the minutes from our July 8th meeting. Has everybody on the commission had a chance to review those? Would anybody like to recommend any corrections or vote to approve the minutes as submitted?
Motion to approve.
Any seconds?
Seconded.
All right, all those in favor?
Aye.
Aye.
Any opposed? All right, hearing none, those minutes are be adopted. All right. Today's agenda includes requests for design alternates from the city's Unified Development Ordinance. When hearing requests for design alternates, the commission sits as a quasi-judicial body and conducts an evidentiary hearing on the request. That means it is like a court hearing. State law sets specific procedures and rules concerning how this commission must make its decisions. The commission's decisions are constrained by the standards in the city's ordinance and the facts presented at the hearing. The commission hears and considers evidence presented and applies the standards set forth in state law and the city's ordinance. The commission must base its decisions upon competent material and substantial evidence presented at the hearing. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. This meeting is open to the public, and everyone is welcome to watch. However, participation in evidentiary hearings is limited. Parties have rights to participate fully. Parties may present evidence, call witness, and make legal arguments. Witnesses may testify to the facts to which they are competent to testify, so long as those facts relate to the legal standards. In addition, lay or non-expert witness testimony is limited to the facts, not opinions. For certain topics, the commission needs to hear opinion testimony from expert witnesses. These topics include projections about property impacts on property values and projections about impacts on traffic safety. All right, we will now open the evidentiary hearing for DA 09-2026 on today's agenda. Jessica Gladwin will introduce this item. And
Chair Springer, if I may.
Yes.
You may wish to identify the members who are seated at the dais as the members that are participating in this hearing.
Yes, everybody seated at the dais will be listening to and voting on this matter. All right, Jessica, before you begin, may I swear you in? All right. Do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right. Thank you.
All right. So to begin, the site we are discussing, it's a 1.02 acre site highlighted in red on the image on the left in North Hills. It is zone CX20 CU, and it's in the SHOD 2. ASR 24-2026 is currently in review for this site. This is an image from the plan set, and it's for a proposed 15-story mixed-use building with retail, residential, and structured parking. So the applicant has requested a total of 6 design alternates for this project, 4 for transparency and 2 for building massing. So they are seeking relief from the ground story transparency requirement on both Lassiter Mill Road and the side of the building that faces Interstate 440. And they're also seeking relief from the upper story transparency requirement for the second story on both streets. These are the kind of general standards from section 1.5.9 from the UDO regarding transparency and its intentions and how we measure it. This is the general requirements and what's the 50% for ground story and 20% for upper stories. And then these are the findings for transparency. Had a chance to review those. Okay. And then they're also seeking to design alternates for building massing or the step back requirement on both Lassiter Mill Road and along I-440. And that's relief from the 12-foot requirement. Since the building is 15 stories, there's a minimum 12-foot step back requirement. Let's see. There's a little bit of description there. And then these are the findings for the building massing.
Chair Springer, I apologize if I may interrupt. I believe we have too many members.
Yes, and I asked Kara that she would, or informed her rather, she would be a non-voting member. Since she does sit on the body, she could sit at the dais, or would she need to either sit at the back of the room?
Yeah, I would recommend
Okay.
that the member not sit at the dais.
Okay.
And that you reaffirm that the members that are seated are the members that are participating in the hearing.
Thank you, Kara. Again, everybody seated here is going to be observing and voting on this matter. Thank you.
Thank you.
All right.
Okay.
Thank you, Jessica.
Go
All
ahead.
right. Before the applicant presents their case, I do believe there were other parties seeking stand-in if they would like to approach and state their case. Pat, do I need to swear them in, or if their attorney, are they good?
The legal counsel, no,
Okay.
but any of legal counsel's witnesses, yes.
Okay, thank you.
Yes, good evening. Thank you, Mr. Chairman and fellow commission members. My name is Brady Herman. I'm a land use and local government attorney from the Borough Law Firm in Chapel Hill, 1526 East Franklin Street, Suite 200. I'm here on behalf of my client, Ms. Shireen Ibrahim, who resides in the North Hills community at the address of 4109 Lassiter Mill Road. And her residential home directly faces the building site at issue and is less than 100 feet directly across the street over Lassiter Mill Road from the applicant's proposed building site. The reason why I'm speaking here from the onset is we request the opportunity to establish that Ms. Ibrahim has legal standing to participate as a party in this evidentiary hearing in opposition to the applicant's design alternate request application. I'm not sure how often this comes up before you all. Your counsel knows perfectly well standing, and it's a very heavy litigated issue, but it's established by statute. And essentially, it's a legal term of whether or not a third-party property owner can participate in the evidentiary hearing just like the applicant, as opposed to just as a general witness. Which state law requires that a person must show that they will suffer special damages as the result of the decision before you. So here, as the result of the design alternate application is approved. The term special damages has been defined as damages that are distinct from the rest of the community. So in other words, it's got to be damages or some particularized harm to my client that's separate and apart from damages that the North Hills community would otherwise suffer as a result of the decision if the application is approved. So what I'd like to go and do is first hand out an affidavit from Ms. Ibrahim that thoroughly sets forth her position and as well as her allegations for why she will suffer special damages that are specific to her property, given negative impacts that will stem from the application and the requested relief from the UDO requirements as it pertains to the transparency and also step back and building mass requirements, all of which are damages that are separate and apart from damages that the general community would otherwise suffer if this application is approved. So what I first would go and do is, I guess the name tag, I don't know who the clerk to the board is, but I'd like to go ahead and pass out Ms. Ibrahim's affidavit, and I would also like to give applicant a copy as well. there should be 11 in there, or maybe 9. And if we need another one, I have one extra copy. And I would also like to call Ms. Ibrahim to go ahead and testify as to her damages and for her to briefly explain, and summarize her affidavit in support of why she has legal standing to participate as a party in this case. So at the pleasure of the commission and also, Mr. Chair, can I have Ms. Ibrahim come and testify
Yes, I would
briefly
like to
on
swear
that?
her in, please.
Okay.
Ms. Ibrahim, do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I will.
All right, thank you. Please proceed.
Okay, Ms. Ibrahim, would you please state your name and address for the record?
Yes, my name is Dr. Shireen Ibrahim. I live at 4109 Lassiter Mill Road,
And you live in the North Hills community, is that correct?
North Hills community.
And where is your property located in relation to the building site that's at issue today?
It's directly opposite from the building site,
And would you say that's approximately how many feet? Less than 100?
about less, 100 or less.
And so your residence completely, your driveway in the front of your house completely faces Lassiter Mill and as well as this building site?
It does.
And how long have you lived as your residence for?
27 years.
And why did you choose to live in the North Hills area?
I love North Hills. When we first came here 55 years ago, that was the only mall that there was in Raleigh. And we had lots of good memories. So when I completed my residency, I decided to come back to North Hills. And I chose my home because it had a wide expanse and a nice view of North Hills, and also I could see the sky.
And in terms of the agenda materials that were in the agenda packet, and as well as the applicant's design alternate application, have you reviewed those agenda materials as well as the associated plans?
I have.
And are you aware of what the applicant is requesting from this commission in terms of the design alternatives for this project and the relief from the UDO transparency requirements, and as well as the building massing step back requirements that
I
they're
do.
seeking relief from?
I sure do.
Now, in order to have standing to participate in this evidentiary hearing, a third party like yourself opposing the application must show that it will suffer special damages as a result of this decision before this commission. Do you have an affidavit to that effect setting forth why you will suffer special damages
I do.
in this case?
I do, and we submitted it to them.
Okay, and I'm just handing you a copy
I have.
of that affidavit.
Thank you.
And can you confirm whether the copy that I just gave you and the one that we distributed to the commission and also to the applicant is a true and accurate copy of your affidavit, Ms. Ibrahim?
It is.
And on the last page, I believe it is page 3, you signed that affidavit under oath, is
I
that
did.
correct?
I did.
And that's your signature there?
That's my signature.
Okay. At this time, I would like to go ahead and enter into the record Ms. Ibrahim's affidavit.
Thank you.
I guess I'll wait to go and document what our exhibits are until, if or when this board finds that she otherwise has standing.
It is for us to decide if Ms. Ibrahim.
Sorry, I
Sorry.
got it. Yeah, that was just the setup. Here's the meat of why she
Okay.
has standing. I apologize.
Chair
So-
Springer, if I may, this will be presented.
Yes.
Right? And the applicant may wish to oppose before
Before the board.
we
would
reach a
consider.
decision, yes.
Okay. All right, please do.
So, Ms. Ibrahim, can you briefly summarize the allegations in your affidavit for why you have standing and why, as a result, if the application is approved, why that would go and otherwise you would suffer, you and your property, damages that are distinct to your property, that are separate and apart from damages that the overall North Hills community would otherwise suffer?
Well, the intent of the proposed design alternative, which Mr. Kane is intending to flout the UDO rules, He intends to flout the transparency rules, the setback rules, the setback rules, and amass more of a building mass, leading to a larger and more imposing building. So therefore, there'll be a giant tower in front of my home, and this tower will be just blocking all my sunlight. And I live in a single-story home, and this is going to be 15 stories. But if they are not going to apply the setbacks and the step backs, then it will not allow any amount of light to filter through onto my property. I won't have a yard. I enjoy gardening. My sun-loving plants will not grow. In addition, he's planning to actually, it's not exactly just a design change. The building is turned around so that the back of the building is the service entrance, will be directly up facing my home. So I'll have a loading dock, a service entrance in front of my home. There will be a garage, 5-story garage. 3 of the stories will be above ground. And that is unacceptable because we already have a loading dock in front of the Highlands, and we see how that goes. I mean, the increased noise of the trucks, the loading, unloading, the back alarms, the screeching noise, which usually happens early in the morning or late at night. There's fumes from the diesel trucks. They're usually left idling for prolonged periods of time, and they are generally unattended. And then you have the stench from the garbage bins, which are regularly left outside of the curb of the Highlands and on the sidewalk. I expect the same will happen in this situation. We have tried to change that multiple times all year, but nothing's changed. There are the fumes, as I said, from the diesel fumes. And it's an unsightly and unbecoming view. It's an unsightly view, and it's unbecoming to North Hills. It's actually I know you don't want emotions, but this is an insult to the residents living across the street. It's unacceptable, and we cannot live under those conditions. I did not sign up for this when I bought this home. I thought this was going to be my long-term retirement home. I intended to do structural changes. I intended extend the house, but that's all been shelved because I was advised that there's no point in spending money in a home that you might not be able to live in, unlivable and unsellable. It's also most likely just reduce the value of my home because who in their right mind would want to live in front of such conditions? Nobody. Nobody would want to live without a yard. Nobody would want to live in front of a loading dock where they're up all night. I mean, I don't mind getting up and going to see a child in the emergency room at 4 o'clock in the morning, but I certainly don't appreciate being woken up to hear these trucks with their idling and beeping and all that stuff. So essentially.
Thank you, Ms. Ibrahim. I think you did a good job articulating sort of the allegations that are set forth in the affidavit. And just to go to briefly summarize, it's the decrease in the amount of shade or the increased shade, rather, in the loss of natural light, all due to the elimination of the transparency requirements, the larger building mass, the commercial loading dock operations, and the noise and traffic that stems to them. That's your allegations in terms of
Yes.
Why this project or this application, if approved, could diminish the value of your property and the quiet enjoyment of your property.
Yes, correct. All of the above.
And so these impacts are specific to your property that would not be experienced by the general, North Hills community as a whole.
No. I mean, some of the homes that are directly across the street, most of them now are being rented or just not lived in.
Okay, so at this time, for all the reasons that Ms. Ibrahim just testified to, and as well as her, testimony in her affidavit, we would ask, Mr. Chair and the commission to find that Ms. Ibrahim has a standing to go and participate as a party in this evidentiary hearing.
Great, thank you. Guessing the applicant now would offer the rebuttal before we
Yes.
consider.
Yeah, if there's opposition, this would be the opportunity for opposition. And then after opposition is presented, you may have questions, including questions from me.
Does the applicant wish to offer a rebuttal?
I'm sorry?
This is a question for the applicant, I'm sorry.
Oh, do
Thank you,
want
Ms.
me to get
Ibrahim.
up?
Stay right there. I've got some questions. Good afternoon, Mr. Chair, members of the commission. Michael Birch with the Smith Anderson Law Firm here on behalf of the applicant. So we do oppose the request for Ms. Ibrahim to participate in this hearing as a party. And so to that end, I will ask a few questions of Ms. Ibrahim and then make an argument after that.
First, can I ask you a question?
No, ma'am.
No, ma'am?
No, ma'am.
Okay, no, ma'am.
Right. Ms. Ibrahim, are you a licensed appraiser in the state of North Carolina?
No,
Are you an architect or an engineer?
no, I'm a physician.
And have you, to support your affidavit, what studies have you done to justify the position that your yard will be impacted by shade or any other claims that you made?
Oh, with all due respect, sir, if you even go to Lowe's and buy any kind of plants, they'll tell you these are shade-loving or these are sun-loving plants. I have sun-loving plants, and I enjoy roses, I enjoy a lawn. These all would not grow in the shade, in a large shaded area, as you well know, probably, if you have a yard. I have a backyard, and when I had a lot of trees grew, the lawn didn't grow. And I would prefer a lawn and also flowers and roses and flowering shrubs.
So have you done or have prepared any studies, any shade studies or otherwise?
I believe the expert witness has.
Okay.
And it showed my home to be directly impacted in front of this building.
Great.
It's a long shadow, actually, and it's longer in the wintertime than it is in the summertime.
And have you prepared or had prepared an appraisal establishing or demonstrating the impact on property values that this building may have?
No, because I know it's going to be, nobody would want to live there. Would you like to live there, sir? Would you like to? I know you don't want me to ask any questions, but I'd like to see. Okay, sorry.
That's right. Right. And right, you're on Lassiter, and you're familiar with the Highlands building,
Yes,
correct?
I am very.
And you're aware, you think you mentioned that there are
Yes.
existing loading and service operations
Oh, yes.
there today?
And a stench
And
and garbage lining the streets, the sidewalks and the curb.
Right. And have you had a traffic impact analysis or any other traffic-related study done?
I can show you pictures of all these trucks that are actually, we've sent them every day. We send the pictures of the trucks. I have them on my phone. Of these trucks that are obstructing the traffic in the turning lanes, and actually they obstruct the view of any, like a bicyclist. The bicyclist can't make a right turn because they're the massive trucks there loading and unloading. And they usually don't go in the loading, they'll dock, they'll no matter how many times they're told, they'll just leave them outside and load and idling, and they load and unload.
Okay. I think that's all the questions I have for right now. So, Mr. Chair, members of the commission, yes, we would continue to object to Ms. Ibrahim's participation as a party. The statutes require that a party establish special damages that results in a impact to property value. Only experts may testify to establish an impact on property value, and you've heard that there is not an expert appraisal report to that effect. I'll also note that what is in the affidavit rises just to the level of lay opinion, not expert opinion. No studies supporting those allegations have been provided, and that is what is required to establish standing and to participate in this hearing as a party. So for those reasons, and let me also say, we don't have a map up in front of us, but I believe Ms. Ibrahim testified that there are a number of residential properties south of Pamlico, essentially between Pamlico and Currituck. All of them are residential properties, whether owner-occupied or otherwise rented. All of these are in proximity to this proposed building, and so we also would contest that the impacts being claimed by Ms. Ibrahim are not unique to her property, but if there were such impacts, that they would be experienced by other properties, potentially along Lassiter Mill Road. So,
Thank you, Mr. Birch. Is that permissible?
It's permissible to have a response. I do have a thought for you. There is a leading case in the state of North Carolina on the subject of standing. It's a land use case. It had to do with property right here in Raleigh. This is a quasi-judicial proceeding. You're sitting very much like a court. It would be fair in court to ask counsel to explain to you how their arguments square up with this leading case. The case is called Cherry versus Wisner. I have no doubt counsel knows this case, and that may be insightful to you. You don't have to do that. That's my observation and suggestion to you.
And that case was Cherry versus Wisner?
That's correct.
All right. Counsel, are you able to speak?
Yeah,
To
I
that
feel like
matter.
I'm doing a CLE on standing on special damages, but here we go. Yeah, so counsel to your commission is right. Cherry v. Wisner is a case on point. And actually, to be candid, I printed off a copy of that before I came in here, which actually they cite even, I think, more precedent case law that came from this jurisdiction called Mangum v. City of Raleigh. That was a Supreme Court case. Cherry v. Wisner was about 10 years ago of a Court of Appeals case. And why that gets a little bit relevant here is in that case, it was actually before the HPC, and the property owner at the time actually didn't allege any allegations at the HPC hearing. And, you know, whether you guys know or not, HPC has actually two appeal processes. You go from the HPC to the Board of Adjustment and then the Superior Court. And so what happened in that case is the property owner made, you know, generalized allegations that they did not like the aesthetics of this proposed house that was directly across the street. And they didn't allege any of these allegations until they went and appealed into Superior Court, which is completely opposite of what happened in here. What the court in Cherry eventually held is and says, look, you know, special damages, you can't just say, I'm going to go and suffer damages that everybody else would otherwise go and suffer. And that is not the case here. And to be candid, if you were to go and look at any of the site plans that's a part of your agenda packet, I mean, you can see that her property is literally directly across the street, and she's going to be seeing these loading docks every single day. Now, she doesn't have to go and be a traffic expert to be able to go and testify as a fact that if you're going to have loading docks there, commercial trucks entering in and out, that's a fact that's going to go and happen. And so I think that further goes and substantiates that she has standing in this case. Let me go back to Cherry real quick, because I think it's prudent to tie in not only that case, but also Mangum v. City of Raleigh. And I'm just going to quote real quick from the case. So the respondent here being, I believe it's Miss Cherry, makes no allegations of damages particular to her property, like allegations of potential vandalism, safety concerns, littering, trespass, and parking overflow in Mangum, or the allegation of the loss of waterfront view and the resulting reduction of market value of the property, as in this case, Sanchez. And then it goes on to hold, because respondent has failed to even allege special damages, she is not a aggrieved party and thus lacks standing to contest the committee's decision. So that's completely opposite of what's here before you today in terms of the allegations in her affidavit. And I'll go to the point of what Mr. Birch said in terms of, competent evidence that has to be submitted through expert testimony. He is 100% right on that. But that has to do with the actual merits and substance that's before whatever quasi-judicial decision-making body. And the best example to go and use is, let's take special use permits. Typically in special use permits, you have a standard that either the applicant or the opposing side has to go and find whether or not it will decrease values of property. So in that instance, you would have to go and have expert testimony. Here, it's just the mere allegations. You guys sit as essentially a trial court. If I were to go and proffer that Ms. Ibrahim has standing to the trial court, what the court would go and look at, essentially their review would be taking those allegations as true in light most favorably to Ms. Ibrahim. So that's what I contend to you all, is to take those allegations as true. The allegations in there are specific to her property. And I apologize for probably over-explaining it. I'm glad counsel went and brought up that Cherry case. But happy to answer any questions by me or Ms. Ibrahim. But we respectfully contend that you all find that she has legal standing and that she should participate as a party accordingly. Thank you.
Before you present, I believe we need to decide as a commission if she has standing or you responding.
I'm
Okay.
responding. And
Please go ahead.
Yeah, a response would be appropriate.
So a few things. First, as described, what Cherry v. Wiesner said, or the context of that decision, first, which just for the board's understanding, Ms. Cherry was found to not have standing, right, ultimately. But the discussion of standing, right, I believe Mr. Herman made reference to quotes in the case where the opinion was saying, because she didn't even allege standing, right? That, because she didn't allege standing in that case, the court did not address whether someone's mere allegations of special damages, unsupported by expert testimony, is sufficient to establish standing. So while they may have provided more than Ms. Wiesner at the RHDC or the COA committee, right? Ms. Wiesner provided zero. What we have here is just mere allegations unsupported by evidence, and the Wiesner case did not address whether just those allegations unsupported by expert testimony is sufficient to establish standing. I'll point to you to Ballot v. City of Greenville, where neighbors were contesting a rezoning, made allegations as part of their complaint contesting the rezoning case, made allegations, and the court rejected standing because those were mere allegations. Additionally, the court found that more than one property would have suffered similar impacts. I know that is an unpublished case, but it was unpublished and referenced cases supporting that same proposition, and the Ballot case was after the Wiesner case. So want to touch on that. There was a reference to commercial trucks, right? These things already exist on Lassiter Mill Road, right? All of these conditions exist on Lassiter Mill Road. And there's been no testimony, no expert testimony, that what is being proposed here, and not even that, just what alternates are being proposed here, actually lead and would cause these alleged special damages. So for those reasons, we would continue our opposition and contest standing.
Thank you, Mr. Birch.
I'm sorry to keep elongating this. May I respond?
Yes, please.
Okay. Sorry to go and beat a dead horse, but let's go back to the Cherry case. The court said in this case, respondent alleged that she would suffer special damages because the Cherry Gordon House, and this is Wisner, house is directly across the street from her home, and that its architectural incongruity would harm the character of the neighborhood and contribute to the erosion of the neighborhood's value. Okay? Generalized damages to the community as a whole. Then the court goes on to go and say is, these allegations do not demonstrate special damages distinct to the respondent, other than the view from her front porch. Rather, respondent alleges a generalized damage to the overall neighborhood, reduced property values, and impairment enjoyment of the neighborhood. And so, again, we're not saying that the whole neighborhood is going to go and be harmed, and that's why Ms. Ibrahim has standing. We're laying out the facts that are relevant into this case. They're asking for a reduction of the building transparency and as well as the building mass. The whole point of those regulations is to actually go and have more sunlight and have more transparency coming through the building. So it's a logical conclusion that by alleviating from those requirements, it would cast more shadow. That's an impact directly to her property because it is directly across the street. And moreover, just because that there are trucks that are already existing there, again, there's going to be a driveway and a loading dock and as well as a roll-up storage doors that are going to be directly across the street. So those, the headlight and the running of these vehicles at odd hours of the day, that again is specific damage to her property. And I'll go back to what the Mangum case said essentially, you can establish special damages, through negative secondary effects. And that's exactly what's going to go and happen here. The quiet enjoyment of her property is going to go and be impacted. So for all those reasons, why I anticipated opposing counsel would go and object to this. I would if I was in the same place as he would, but I think we have a very strong case that she meets the standing requirement in this case by her affidavit and as well as her testimony.
Thank you, Mr. Herman. Mr. Birch.
Last thing I will say, in addition to unsupported allegations, there's also been no testimony or supported allegations that these special damages are distinct from the other residential properties between Pamlico and Currituck that all front along Lassiter. There are multiple properties directly across from this development. So, thank you.
As a commission, we will decide if Ms. Ibrahim does have standing.
I'm sorry, Chair Springer. You were given, the commission was given an affidavit. I would recommend that you, on the record, say we accept the materials into the record.
All right, the commission accepts the affidavit and materials submitted to the record. And now we will decide if she does in fact have standing in the case. Is that a kind of similar to our discussions when we bring matter to the table to discuss?
It is. I mean, you could close this portion of the hearing and then have a discussion and then make it clear that the hearing is reopened afterwards.
Okay, the commission will close the hearing, discuss this matter, and reopen with our decision. All right, would anybody like to start off with our thoughts on standing? I know most of us don't have a law background. Yeah, I think of our city attorney, you're welcome to ask questions.
I can hear you.
Sorry, Casey.
Sorry, if you're not speaking to the microphone, it's not picked up on the recording for folks that are listening in or watching in online. Thank you.
Thank you, Casey.
Trying to phrase this delicately in an appropriate way. If the affidavit or, we have another participant in this hearing that's coming up, and they have heard from the applicant that there is no basis for their joining the meeting because they don't have certain documents that are, at this time, that are signed by a professional, be that a appraiser, an architect, or, whoever that might be. Is it fair to request that they be given such amount of time to produce such a document before we make a decision on whether they should be here or not, which would effectively, continue this discussion to a later date?
You have an option here. You could ask the parties to brief this and support their positions in a brief, and they may elect to provide you with materials that support the brief. But I would recommend you turn that option, if that's something you want, to the parties here. I won't say parties, to the proponents here, and get their input on their willingness to do that.
And does such a request, does that and somehow harm the applicant? Meaning that it would, do you know what I mean? Like, do they have certain rights by all of the law that's being quoted right now, and we are not expert to?
Yeah, does it harm the applicant? I think
Maybe
it's-
that's the wrong word.
Well, I think it's fair to ask. Again, quasi-judicial, right? You're sitting like judges. It's common, for a court to say, okay, you're arguing this, I'd like you to brief it for me. And then the court can give it due consideration. That would, I'm sorry, I should say more. I think that would put a pause on everything then, and we'd be coming back another day for other things.
How does the commission feel about asking for?
That's where I was headed as well, to ask if they were intending to provide expert witnesses for us at any point. I understand the question is, are allegations without expert testimony enough to establish standing, is what we're discussing. I think as a design review commission, we are charged with listening to expert testimony. So when we actually get into the hearing, we would be expecting expert testimony on which to make our decision. So whether or not someone can enter their allegations without expert testimony may or may, when we actually get to the hearing, we would be expecting expert testimony to be there, period. So I would say probably let's open back up the hearing and ask that question.
All right. Yeah. Is the rest of the commission okay with that? All right. The commission's reopening the hearing. Question for the applicant, or rather, Mr. Herman. not the
Actually,
applicant.
I did one thing.
Sorry. I'm
Sorry.
We're gonna
Sorry,
close
should have
this.
said earlier.
Apologies. Sorry for missing you.
I kind of want to just disagree a little bit because I know we do obviously accept expert witnesses, but we, at one point during the hearing, we opened up to the public. And if we just delete that now, then what's the point of opening up to the public in general, at least in my eyes?
I don't think we are deleting that now.
Well, that's what it
That
feels
would
like.
still be available.
Well, I guess maybe postponing it might be the better word than deleting it.
Yeah, I don't think we would then, to kind of echo what Kay was saying, be excluding the public from the right to comment on the matter, but rather seeking to allow the opponent, for lack of a better phrase, to the applicant, the ability to provide maybe that expert testimony for the claims they're making here.
Understood.
So,
I think also, to be clear, we're looking for visuals that demonstrate the validity of the
yeah,
claims.
which would also be expected of the applicant in the request for the deviation from the UDO in this case. All right. So with that, do we want to request a brief?
Yeah.
All right. Reopening the matter for Mr. Herman, client, Ms. Ibrahim, would the parties be willing to submit briefs to the commission, laying out the arguments in a concise fashion for us to deliberate further?
I guess to answer that question, that's better than saying that Ms. Ibrahim doesn't have standing. So with that, I'm open to that idea. I would just like to go and say that, everybody's here. I do think that we've done more than enough, not only her, having me here to go and represent her or just get in the door to go and have standing. I think we've overcome, a very high bar. And if the bar is that we have to have expert testimony on any single time that someone has standing, I don't think that's what the law goes and contemplates, because then you'd have to go and hire not only attorneys but experts as well. But with that, we do have, if Ms. Ibrahim is found to have standing, we do plan on calling an expert on the merits that's actually before you all on your quasi-decision-making authority in terms of the facts in this case and the standards that you all have to go and find one way or the other. So, I'm not against that idea if ultimately this board was going to go and say that, Ms. Ibrahim doesn't have standing, but to the extent that we can go and continue on with the hearing today, that would be our preference. So with that, does anybody have any questions?
Commissioners, any questions?
I do have a question for you. Is Ms. Ibrahim relying on the expert testimony that the applicant is providing to give information related to the impact on her home?
Well, the impact on her home has nothing to go and do with the standards that's before you all on whether, their alternative design meets the intent of the, transparency requirements. I mean, again, there's some cases where, the standing on reduction of property values or increase in traffic play a part into the actual merits of what's before the quasi-judicial making body. Here, they're completely opposite, right? I mean, we're making allegations of her damage to just be a part of this evidentiary hearing. That's completely different from, we have a plan on going and calling an architect expert, in architecture to actually, give expert opinion onto the standards. So, again, it's not like we're just relying on Ms. Ibrahim's lay witness testimony to be here in front of you all today.
Okay, so follow-on question, just to make sure I have this correct. You're alleging, or you have purported that, this is in my notes, that we as the Design Review Commission have to take allegations as the truth?
Well, that's how a trial court tribunal will go and take those. If it was something that, let's say, we filed a complaint and the other side at that point could say, you don't have standing, that's a jurisdictional matter, then the court, that would essentially be what's called a motion to dismiss. And on that, the reviewing body or the reviewing court takes those allegations as true and light most favorable to the non-moving party. And here that'd be most favorable to us.
Thank you.
Yeah.
Any other questions for Mr. Herman? Mr. Birch?
I would ask for the commission to move forward with a hearing today. I think as was clarified right? This is not an issue of whether Ms. Ibrahim can speak or any other members of the public can speak. It is really just related to the participation as a party. I think our experts are here. It sounds like they have an expert here as well. You know, it would be our preference to be heard today, because I think that, right, we come back in a month, okay, we've briefed the issue, right, things can happen during that time as well, and I think we're ready to move forward today. And again, so, yeah, we're here to answer any questions. If you want to move forward with parts of the hearing and maybe revisit this at a later point in the hearing, well, we would be open to that as well.
Thank you, Mr. Birch. I'd like to close the hearing again, discuss amongst the commissioners, and then reopen this.
And I have a question for you.
Go ahead, Shravya, please.
No, you go ahead. You have sounded like you had something.
I mean, I would like to hear your question first before I speak what I was going to say.
I guess I'm trying to understand the situation here and what the implication is if we were to accept the allegation or the Ms. Ingram as Ibrahim as an affidavit or in terms of allegation. Would that require the applicant to address the concern or make some sort of adjustment to that alleged? What's the definition? Sorry, I'm not doing the right. The person who's actually making the claim, would that be the consequence if things were to kind of move forward?
If the individual who is asking you to find that the individual has standing, if you were to find standing, we would then proceed.
Yeah.
You'll have made your decision, and this would move forward. And we heard already that the applicant will continue to object. But you would proceed in the face of that objection.
Okay.
Sorry, and I think my question for you is, if we do find Ms. Ibrahim does have standing, does that change how we would really conduct the evidentiary hearing? I think the burden of proof would still then be on the applicant to explain to the commissioners why they deserve the design alternates to be granted as designed and presented to us. What then would, aside from her ability to object to the points made by the applicant, does that change much of how we would go about hearing the case?
So standing goes to due process, right? There's a lot at stake, constitutional due process. And if you were to find standing for the individual who's requesting it, they would participate, she or they would participate as a full participant, as a party, and would have all the rights that the applicant has to cross-examine, to examine evidence, everything, the full range of rights that a party would have, equal footing.
With
Isn't
that,
it assumed they're an expert, though, to be at the podium here? Isn't that one of the criteria typically?
So to find standing or to participate in the hearing.
Participate in the hearing.
So-
Don't you need to be an expert in some way to even comment on the subject matter?
It will be up to the party to present their evidence, their testimony, and you'll evaluate that. And, as the commission knows, there are certain kinds of testimony that you can't rely on, that's inadmissible, certain kinds of testimony that need to be supported by an expert. And that's going to be up to that party to carry that burden, and present to you in a proper way.
With that being stated, I personally, not speaking for the commission here, don't really want to maybe delay the applicant's, day in court, if you will, much longer. Ms. Ibrahim, if we find that she does have standing, I think the rules of this are laid out rather clearly. She would, and I would assume her attorney probably informed her of such, like needing the expert testimony to back up some of the claims that she may make. So that would then kind of be on her. I'm of the opinion that I would not mind voting in favor of her having standing, and we will hear the case as presented. But I would like the rest of the commission to weigh in on that before we proceed in one direction or another.
I agree with you.
Both of you are saying that there is standing.
Yes. Okay.
Yeah, there is a
Just wanna make sure.
standing. Yeah. mhm.
Yeah, I'm saying that I think our process supports testimony, and we can welcome additional testimony, and we will be able to decide how relevant that is.
Is the rest of the commission in favor with that? All right. When we reopen this, is the correct process to acknowledge the standing of Ms. Ibrahim?
Yeah, you should make a finding and do that on motion and vote.
Okay. Thank you, Pat. All right. Commission's reopening the hearing. We are in finding that Ms. Ibrahim does have standing. We were going to vote on that matter as a commission. All right. All those in favor of acknowledging the standing of Ms. Ibrahim? Aye.
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 All right. Any opposed?
Yeah.
All right. One opposition. Pat, do we exceed the threshold then in favor that the Ms. Ibrahim does have standing in this case?
Yeah, would you kindly clarify the vote? How many for and how many against?
8 in favor, 1 against, and was Commissioner, I cannot see your last name here, but Chris, thank you.
So that's suitable for, I used the word finding or determination that the party now is a party and has standing.
Thank you. With that, the applicant, are we going to allow them now, would proceed in a normal fashion? Okay. The applicant will now present evidence and legal arguments in support of the request. As a reminder, any evidence and argument must focus on the applicable standards. All right. And Mr. Birch, just for decorum, before you begin, can you please restate, for the record, your name, address, and relation to the case?
Yes, Michael Birch, law firm of Smith Anderson. It's 150 Fayetteville Street, Suite 2800, Raleigh 27601. Attorney for the applicant.
There you go.
So, a couple of just intro items. So, with me this afternoon is Rob Rule, architect for this project with Rule, Joy, Trammell, and Rubio. We also have Jonathan Balderson with McAdams, the project engineer. On the front end, want to pass up to the clerk or to the chair 3 items. First is a letter from me just affirming that I continue to represent the applicant. I filed the application when I was at a different law firm, and so city attorney asked that I provide a letter affirming that. And then also we have some wedding original signature pages that were updated per the city's request. Again, same signature, same ownership entity. They just wanted a few things in the certification changed. So I can pass those up.
Thank you, and those will be submitted into the record.
Thank you.
Chair Springer, I would recommend some formality for this, that the commission by motion and vote, first of all, accept the application is filed into the record so that there's no doubt what's been put in. And second, accept and admit into the record the applicant's updated ownership certification, which has been provided to you, nunc pro tunc, and I'll spell that out for you. That means now for then, right, as if it had come in originally, as of the date of the applicant's filing. And then third, accept the letter of the applicant's legal counsel stating their representation.
All right. Commissioners, I'm probably going to look to you for help on all three of those points again.
Sure.
I guess, would we vote on these all together or independently?
All together is fine.
All right. As Pat alluded, to accept the materials as submitted regarding the DA matter, the updated ownership form, and then accepted letter of, can you help me on that last one?
Yeah, the letter of the applicant's legal counsel stating their representation.
Yes, the updated letter of legal counsel's representation into the record.
And if I could just clarify,
Yes, please.
and for the second item, the ownership certifications accepted nunc pro tunc, now for then.
All right. I'm going to butcher that Latin.
No
May I
problem.
do the plain English. We will accept the letter of the owner in the Latin that I would butcher now for then into the record as well.
Yeah, the ownership certification.
The ownership certification. All right. Open that motion to a vote. All those in favor?
Aye.
Aye.
Any opposed? Hearing none. Thank you. These will be entered into the record.
Thank you. Also, at the outset, would ask that our application, the staff presentation, and our applicant presentation be accepted as evidence in the record. And would also like to pass up just 11 by 17 copies of 6 of the slides that are in the presentation. And Randy, I'll grab one for you as well.
Thank you for these supplemental materials.
Great. In our presentation, we'll touch on those slides, and we'll have Mr. Rule speak to those as well, but just wanted to go ahead and get those in your hands on the front end.
All right. Thank you.
So want to set the stage for this proposed building and put it in context of what's been going on at North Hills. So you have in front of you kind of call it the old mall part, about 28 acres between Six Forks, Lassiter, and 440. Let's see if I can get, okay. So you may remember that, the J.C. Penney was kind of in this area here, right? J.C. Penney, as well as some surface parking lot, was in this area. The first phase of what's called the North Hills expansion, right? Demolished the J.C. Penney and put in its place the Highlands building here, the RH building here, as well as 2 office buildings there. The property that we're talking about is down here. Initially included in the ASR, but the specific development removed at that time public improvements were still provided along that property's frontage, just to do it at that time with everything else going on out there. So this plan is essentially, again, phase 2 of that overall project. The RH building is 3 stories. The Highlands building is ultimately 12 stories. Want to note that that project did come in for similar design adjustments, design alternates for transparency for a similar loading operation for the Highlands building. Right. So at the time of that first phase site plan, you've been there, right? This is kind of a main retail street, right? This is, right, there are no pedestrian entrances to the RH building along Lassiter, and no kind of primary public-facing entrance there. Most of that is kind of building operations, loading service until you get closer to this street here, where you start to have then parts of Ruth's Chris in that area. You can see, right, this is all sitting on top of a parking deck, a 2-level parking deck, right? And as part of that first phase, they constructed this access road, you know, essentially with a turnaround, and you can see that it's stubbed here. And so that is kind of where we're, again, we are fitting into a very specific, you know, part of the property where the boundaries and everything around it has been established. So since that first phase was approved and constructed, a rezoning that included both this area here, properties along, you know, Six Forks here, as well as off Rowan, was approved, and this portion of the property was approved for up to 20 stories. And again, that was approved by City Council on January 20th of this year. Again, you can go there. So, what is being proposed here is a 15-story building, kind of above grade relative to where it sits. Again, there are levels of parking underneath. Again, zoning would allow up to 20 stories. This building is at 15 stories. This is the view, again, internal. So Lassiter's kind of on the back side of this image. This is the view of the building facing Lassiter. And this is the view of the building facing 440. We have requests related to both Lassiter and 440. I just, again, want to note why we have some related to 440. This is, again, essentially a condo parcel, but it's part of really one single lot that's 28 acres, and so the property technically has frontage along 440. So the code requires transparency and building step back from public rights-of-way. And so this property, even though it's set back 100-plus feet from 440, is still technically along a public right-of-way. And so those transparency standards and building step-back standards are applicable to that elevation of the building. So we'll get into a little more detail on the findings, but essentially a lot of the policies behind the building massing and the transparency regulations really don't make sense in this context because, again, this is very unique versus what you typically see where a building is kind of right up on the road. just to highlight, before Mr. Rule gets up, we have design alternates related to transparency along the ground story here, as well as the second story, which is a parking level. Transparency has not been required where when there are no building occupants on that level, essentially where there's not, call it habitable space there. And that's why we're not having to include alternates for the other levels of the parking deck. Because there's retail on the interior side of the ground floor, and because a very small portion of that retail comes up, kind of like just a higher ceiling on that other facade at the second level, that's why we're bringing in the second level, even though that is really the only kind of, call it, habitable space there. So, in addition, as I mentioned, this building is 15 stories. A step back of 12 feet is required below the 13th story. Just for context, that would be kind of in this area here. Right, that would be the 13th, 14th, 15th floors above that red line. And all that's required is a 12-foot step back. So what the code would allow, right, is a sheer wall for the length of the building all the way up to 12 stories, and then above that, a 12-foot step back for the next 3 stories. As Mr. Rule will show you and testify, right, and let me just point out, the only places where there is not a step back are on these 2 portions of the facade. In the middle area, there's a step back above kind of the second story, above the 4th story, essentially for the 11 stories above. So significantly less building mass than would be allowed under the code complying with the 12-foot step back. And along 440, on the elevation facing 440, right, it's this elevation here, which is loading, service, and the ramp up, this level of parking, and then again, there is no step back, no compliant step back on that facade facing 440. So with that, I'm going to ask Rob Rule to come up and speak in more detail about these elevations and the building, how they kind of touch on the required findings, and then I will get back up and summarize and conclude. Thanks.
Mr. Rule, before you begin, please state for the record your name, address, and relation to the case.
I am Rob Rule, and I am the design principal architect at Rule, Joy, Trammell, Rubio Architects out of Atlanta, Georgia, 300 Galleria Parkway. And I am the design principal in charge of the design of this project.
All right, and do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Okay, very good. Well, Michael did a good job of giving an overview, but I'll talk a little bit about some of the details related to the alternate findings that we have. So in front of you, you have the Lassiter Mill facade, if you will, and you'll notice that as far as the allowable alternate findings, when we don't have the full step back requirement, would include breaking down the building's mass, which we have done. You can clearly see the mass is broken down quite a bit here, not only in the vertical dimension where we've broken it down to a base, middle, and top, very clearly done in a very traditional fashion, using heavy cornice lines both at multiple levels. We break down the building that way. And then we unify floors where we have some floors that are highly punched, and we have other floors that are joined together with floor-to-ceiling glass. The corners are eroded away with balconies that are actually more like outdoor rooms at some of the corners. So we've really broken down the mass those ways vertically. Horizontally, as Michael said, about 40% of the building has a step back that's much deeper than the 12 feet. It's about on the left-hand side there, which is the north end. That step back is closer to 70 feet. The step back on the south end is close to 50 feet. So 40% of the building greatly exceeds the 12-foot step back. We brought down the two towers on the right-hand side, which is a very classical way of handling the base, middle, top of a building coming down that you see there, and it creates this really, we think is an interesting overall mass. In addition to that, the massing on the right-hand side, the south side, is stepped down an additional floor. So it's 15 stories on the left side, but it's only 14 on the right-hand side. There's actually a amenitized rooftop at the top side there where it steps down. You can see the difference in the rendering there. Looking at the facade that faces 440, once again, it is so far set back from 440. The decision was made there based on functional considerations of the building. We don't have a step back here for sure on this narrow end of the building, but it is the narrow end of the building. But you can see that the facade, the building massing actually steps as Lassiter Mill proceeds at an angle away from 440. So we've done some things here, once again, architecturally interesting to create a variety and artistic interest in the building. At the base of the building, you can see archways. We've got some, the way we handle the detailing at the base with horizontal striations and reveals in the materials and the finishes, the street lighting. And I didn't mention it before, but on both of these facades, this facade and on Lassiter Mill, we have enough setback at the ground floor. We've got a pretty healthy amount of landscaping down there with multi-layered approach with understory growth and ground covers. There'll be multiple heights and multiple varieties. And just going back a little bit, you can see how dense that is in the view there. And we'd also actually include some green walls that actually creep up some of those walls, particularly around the center section where you have the two openings, the two big arched openings for where the service entrance comes in. We actually have some green walls that grow up the building there. So a very robust greenscape program on both of these facades, which is also one of the alternate findings that's allowed when you don't have both the transparency and without the step back. To look at that in the floor plan, as you can see, Michael mentioned it, the yellowish tan area that you see there in the top left corner there, facing inward towards the North Hill development as a part of the overall master plan and how the synergy of the retail works at North Hills, that's the retail space that's in the building. And you saw that on the first rendering that Michael showed, that retail sort of inward facing. It's a natural connection of the rest of the retail along that main retail street that Michael described. When you move to the right, that turnaround area that you see there, it's actually elevated above the traffic circle you see down below. There's a whole story height and difference there. You probably have seen that. So when you arrive, you're arriving in the air at a higher level than you are on that service drive that's over off on the right up there. And that was always master planned to be the entrance to this development in the master plan. So that's why you can see how the parking drive comes in right there. So retail where it needed to be on the master plan, the parking entry drive, and then between that and the brighter yellow is the actual arrival lobby for the residence space right there. That was sort of shoehorned into that master plan. Everything behind that, and we made it as small as we could, is all of the service components that are required for a building that this building is. So the loading dock, all the mechanical, electrical, plumbing, fire risers for the fire protection, all of those things are in those dark gray areas, and you can see how those are planned in. And yes, the service dock is accessible by two openings onto Lassiter Mill, very much like the Highlands is, that we all know where the trucks pull into the building. There's no maneuvering on the street. They maneuver within that gray space, and that's partly why the gray space is the size it is. You're maneuvering entirely indoors because it's a requirement and it works, and so you're maneuvering and then you pull back out. So that's the way the service area works. And then you can see also on this drawing, we've got a healthy setback from the streets on both the 440 side and Lassiter Mill that we're embellishing with a great amount of landscaping that we normally wouldn't see. And in fact, you don't see that at Highland. We're doing much more here like I said, multi-story growth from the ground covers to understory into canopy trees, and then the green walls going up in that center angled section that actually flank around the loading dock doors. And just blew those up for you so you can see the amount of detail I've been referring to here, both in the plan on Lassiter Mill and on the elevation in front of you there. All the elements I just described, they're all there with the articulation of the building, the heavy landscaping, the street lights that are there, giving that human scale along the street. All those elements that are allowable in the UDO for alternate findings, they're all here. And then on the 440 elevation, it's more of the same coming down there. Obviously, the power and entrances in the building from the power company have to go somewhere, so they are here on the service drive, which was once again part of the overall master plan of this building when it was actually originally envisioned. That concludes my overall explanation. I did it quickly. If you have any questions, I'm here to answer any questions, of course.
Commissioners, any questions before Mr. Rule steps aside?
Is this just covering transparency right now, or is it the setback?
He did touch on the setback, I believe.
Yeah, I included both. If I wasn't clear,
Could
then
you
I meant to.
sketch with that red marker
How do I do that, Michael?
where the setbacks, I understand how you've created this deep courtyard
Yes.
and exceeded the requirement.
Yes.
But can you show us clearly on the screen from
Yes.
the renderings what facades would have to be manipulated if you followed the setback requirement?
Let's see here, there's probably a better slide. Oh, here, so this may be, so this portion, right, so, well, here, so this kind of feature wall here, and then this portion here. Right, so even though we've got that substantial step back in the middle, because there's not a step back for this, the two kind of areas there, that's where a step back, that's where we're requesting the alternate there. But because of that significant step back in the middle, we think it provides much more relief and meets the intent much more than just providing a 12-foot step back across the entire face. So, does that answer your question for Lassiter, or do you want to see?
Does, and I'm, within the slide deck that's been presented, oftentimes we would see these are the reasons why it meets the criteria of the alternate. And so you're going to get to
we'll
that.
summarize
Okay.
that.
Mr. Rule, before you do step
Yes,
aside.
sure.
It may be in the packet. Is there a daylight or shadow analysis in here?
There
for us
is
to
not.
consider? Okay.
Yeah, there's not right now.
Rob, if you could just speak to kind of how this building form,
Yeah.
right, with both the step down
so-
here and this speaks to light, air, et cetera.
Yeah, so can I draw on the screen? Yeah, okay. So by right, if we're, to be really clear about it, we actually, by right, and that's going off the screen here because that's how high, a 20-story mass along the entire facade by right is what's allowed, but then you need to add the step back. So then what you do is at, say, the 13th floor somewhere, right in here, we would set that back 12 feet. So I'm approximating it, so you basically get rid of that corner right there. And because it applies on the side too, as it comes down over here, you step that back there, and so it gets rid of that corner right there too. And this is minus 12. That's by right, right? If we step it back at any point along that facade. But you can see very clearly that, and I wish I had a different color, but with the mass being 15 stories straight up there, but then having a step back that's 70 feet plus or minus right there, and then from this edge, back into there, it's 50 feet back in there, and then coming down here. We're not building any of that up in there, and then all this middle area, we're pushing that way back. My professional opinion, and we've studied this many times, including in front of this committee, my professional opinion is that a solar study would show that there is no detrimental difference between what we could do by right and what we're doing. I mean, frankly, I think it's worse if we were to do by right build it there. The graphics would show, we can prove that easily. In my professional opinion, this is a better solution than what is allowable by right, as far as the impact on the street and in the neighborhood.
Can I ask a question? Just to be clear, sorry, that's very loud. The part that's non-compliant is the 2 end towers at the 13th floor and
Correct.
above.
Correct. So the big
Okay.
circle around that part there, and then there. Yeah. So it's not compliant by minus 12 feet right there, and then also there.
Okay, thank you.
Kyle, I have a list. You ready? Okay. Based on your understanding of what's going on with 440 and the right-of-way, do you have any understanding of whether or not a change later on the frontage with 440 would make your frontage there more relevant? So could the streetscape get closer? Could the city make changes to the way that 440 is organized on that side that reduces the distance that you've quoted at, over 100 feet, that would make your frontage on that side more relevant?
Yeah. You want to address that?
I can speak to it, and then Rob wants to add in. So,
Or do you have exhibits that can show us how irrelevant it is?
yeah. So we'll just do this. So from this closest point here to the travel lane is 215 feet. From that same point to the right-of-way line, which is right here, it's about 150 feet. Additionally, the travel lanes sit over 20 feet below the ground floor of the building here, like from Lassiter, right? So the ground story will sit more than 22 feet above the travel lanes here. There are power lines that run along 440 as well that aren't going anywhere. And so, right, and then there's obviously this, right, this is a crucial access point. And so, no, I don't think that there's anything that could go on with 440 that would make, certainly from a building massing standpoint, and then from a, call it transparency standpoint, right, these are significantly tall trees here. The ones that are on the subject property have to remain because of the SHOD 2. And then, of course, right, the views blocked by the landscaping that's immediately adjacent to the building. Does that answer,
That helps. Thank you for elaborating on that. A little more on urban frontage. So for the record, can you please explain to us why your building is oriented away from the urban frontage? And so you've got your loading and unloading on what should be and is an urban front. Can you, for the record, please let us know why the building is oriented the way that it is?
Yeah, it has a lot to do with the overall master plan that Michael talked about, the way the site was contemplated from the very beginning, where the retail street was and where the service streets were sort of allocated in the master plan. And because of that, there were some decisions made when the construction was, there was some infrastructure built here. For instance, this raised drop-off and turnaround area, having, service trucks come across the top of that and then serve the building, there's really no way to do that without destroying the retail that was planned on that street up there. Plus the load of the service trucks and everything, we don't know if it would even be viable, but it was just that was the way the overall master plan was, and we sort of have to live with that.
Okay, and did your overall master plan go through a city review process?
Michael?
I can speak to that. So I want to touch on 2 points relative to that question. So first, I want to make sure we're on the same page in terms of terminology. So this property is not subject to an urban frontage district. I think you may have been just more speaking to it, hey, we're putting a building close to a road, but I just wanted to be clear that it did not have one pre-rezoning, and then, did not put one on it during the rezoning, knowing that because how this phase one redevelopment had already been established, that the urban frontage would not work along Lassiter, given how this building had to be designed and oriented, similar to Highlands and to the RH building. So as to your question about the master plan, right? So phase one of the redevelopment actually includes that whole area. And yes, that went through the ASR review, was approved. Again, a building was initially shown there, was withdrawn prior to approval, but everything else you see here was approved as part of that ASR. We came through the variance and design alternate process for the RH building and the Highlands building. So does that answer?
That helps, thank you. Okay. In terms of, I guess, what we're not calling urban frontage, but what we're calling an heavily trafficked area, do you have any, or did you have any consideration for a Lassiter Mill facing pedestrian entrance that would not require pedestrians to migrate to the side streets that are part of North Hills, in terms of access to the internal side of your site? Yeah. What I'm noticing is that you have a big, long area where pedestrians cannot infiltrate into the building.
Right.
And so can you just speak to why that is and how you think that impacts your relationship to the residential environment that is near you?
It's really the safety thing related to pedestrians and the vehicle traffic on Lassiter Mill related to service. They're not being able to maneuver in the street, where trucks can actually back up into a smaller loading dock, which requires less footprint, is what creates that situation where bringing the trucks into that space and having to turn around, it just eats up a ton of the frontage. And then what frontage that was left over, and because of where that, we had to locate that service entrance far enough away from that entry drive that's there to the south. We had to locate it further enough away. That dictated that it had to go on the north end of the site where the service is, and that's sort of a specified, turning radius, all the stuff. We can't dictate that. And then the area that was left over was underneath where the cars were master planned to come in and up into the deck, which you saw in the plan. I talked about that. And so that point is physically disconnected from walking off from Lassiter Mill through the site. And that became the natural spot to put all the other mechanical entry stuff that we need for all the plumbing and the fire protection and everything else in that smaller area in the corner. So that area got eaten up just by those functional things. I mean, I'm sympathetic to what you're trying to do. We tried, but there was really no way to do it.
Yeah, I guess I'm curious if you had given a preference to Lassiter Mill for your retail, could those loading docks have been accessed off of the center at North Hill Street? Could you have flipped your building around and had your loading and unloading be an internal issue?
That's a sort of an ownership sort of question that's answered better with ownership, but I would say that the synergy of retail being next to retail is huge. And if you disconnect that, and right now that would be a very disconnected retail if it faced Lassiter Mill from there, nothing else. Everything else is facing the other way. Yeah.
Can speak to that a little bit as well, just in terms of, right, so this center at North Hill Street is, access drive is already established in place, right, part of the parking structure, right? It was essentially stubbed out to serve the parking deck, sized that way et cetera. A vehicular, for not loading in service, a vehicular ingress egress point on Lassiter Mill would not meet the driveway spacing standards between the entrance here and the entrance here. The only reason that this loading service driveway is allowed is because it is limited to loading and service. So just a general like access to a parking deck for residents, occupants, et cetera, would not meet the code in that segment of Lassiter Mill. As Rob was alluding to, right, all the retail really here, right, is all facing internal, just as it is here, right, all of that. Even along Six Forks. So as Rob mentioned, in terms of kind of disconnecting the retail by putting it here, right, we think would, again, works much more functionally and integrated on the interior side across from office and other active uses that are already established along that street.
Last question from me. You touched on an emphasis on landscaping along Lassiter Mill. Can you speak to how much above the requirements you went with that landscaping? Or how far above the requirements you went?
Okay. Yeah.
Just because that is one of the findings that would be useful.
So really the only thing that is required by code are the street trees, the 4 street trees there. And again, these were all installed per the prior ASR for the overall redevelopment of that area. But I believe there is some small landscaping requirement for those transformers, but otherwise, the landscaping you see between the property line and the building is above the code requirement.
Thanks. Thank you. I'm done for now.
Thank you. Any other questions, commissioners?
Yeah,
Please proceed.
yeah, but yeah, certainly don't want to cut off questions here, but do want to speak to. Maybe bring it back up. Again, wanted to give you all that kind of overview so you can get a working understanding of the building. Before I do that, I do want to note, it's probably the color is better here. Rob mentioned about the impact of the vehicular in and out here. So that is all ramping up from this elevation there. And so unable to fit, you see the limited depth here off the road, right? These are kind of your retail bay depths here. But limited depths here because of the impact of those ramps to the ceiling height in those areas. And again, they kind of continue to come up and start the parking deck, and we have some floor plans to see that in more detail. Just wanted to note that. All right. So transparency, ground story requirement 50%, upper story requirement 20%. We'll touch back on this, but again, the intent of transparency, visual interest for pedestrians and building occupants, and then minimize blank wall area. At the outset, I want to note that we are compliant with the blank wall standards, right? Visual interest for building occupants. There are no building occupants along the facade, the elevation of Lassiter Mill or the part that faces 440. Visual interest for pedestrians, we get at that transparent, or that intent through the kind of architectural and landscape treatments that create visual interest to offset that reduction in transparency. So just want to touch on that on the front end. Again, seeing these slides here, these are representations of the proposed landscaping. Rob also mentioned the kind of green walls here with vegetation to further lend visual interest and mitigate the impact of the lack of transparency along that facade. Again, because of the uses, the electric room, generator room, the pump room, and the loading and service area, all of which is along that whole facade, we are not proposing any transparent materials looking into those rooms. Instead, we are proposing, again, these architectural treatments which are consistent with the loading and service doors across that facade, provides that rhythm, even though there is not transparency. The size, height of those architectural treatments are similar across that ground floor. This is the level here of the parking deck transparency that we're speaking to. Again, everything behind that is parking deck, and those will be screened. We're not asking for any variance or alternate to the parking deck screening regulations. So we will have less than 40% open area, open views into that parking deck along that level. So we are complying with the code on that front. Again, this is the 440 facade here. Again, when we think about the findings, there are no building occupants in this area. This kind of gives you a sense of the grade. There is a sidewalk adjacent to the property, but the transparency regulations, again, are more focused on the pedestrian areas that are within the public right-of-way. We don't have any of those along 440, but that's about a 10-foot drop, and again, takes you down to the lower level of the parking deck, but heavily screened with landscaping there, similar rhythm of the, in lieu of transparency, those treatments along that facade. Again, this gives you a sense of what's being viewed here, the main electric room, and then the ramp up into that parking deck. Again, there are transformers here in front of the building that are also heavily screened.
Is that screened primarily with plantings and vegetation, or is there some structure on the south side of those?
Yeah. I don't believe Jonathan, no structure adjacent to those transformers just because of the transformer regulations, right? So just landscape screening along those. Again, if you want to look into floor plans, this is that second level, that parking level. That's the only portion of that story that is open to the ground floor, and that's why we're having to seek an alternate on that second story, is just because that opening. Otherwise, that entire floor would not be quote unquote habitable, and so the transparency regulations wouldn't apply. But just again, want to note that for you all. again, we need to go back to those on transparency. Again, building massing, we focused on this. All that's required is 12-foot step back below the 13th story. Here. So the intent of the building massing regulations, right? So it's focused on public street, street level, street wall, in terms of where you're mitigating impacts. Avoiding a canyon effect. Again, we have a 3-story building, RH to our north. So obviously nothing to the south along 440, right? And maximum height allowed across the street, 3 stories in the residential district. So in terms of along those public streets where step back would otherwise be required, there's not that issue with the canyon effect. You also heard Rob testify to the access to light and air being provided in a better way with that deep step back in the middle of the building, as well as the losing a story on the south end. And again, just overall, the building being 5 stories less than otherwise allowed by the zoning. And at the ground level, right, we still are providing that consistent street wall, both along Lassiter and the entranceway. And again, Rob spoke on all the different ways along both facades that are going to visually reduce the scale of the building. The base is distinguishable from the building above, again, with all the cornice lines, the step backs, as well as kind of highlighting that volume of the 2 stories at the top, went through base, middle, and top. Again, we talked about the rhythm along the ground floor of those kind of areas with the arches, as well as the landscaping to also provide that rhythm along there. So I want to note on the shadow impacts what the code is focused on: public spaces, amenity areas, surrounding streets. We do not have any amenity areas along Lassiter or, again, to the south of the building, between the building and 440. The surrounding streets are Lassiter and 440. And again, there are no, call them public spaces other than Lassiter and 440 there. And Rob has spoken to, again, how the proposed building design provides less shadow impact than, just strict compliance with the code. So with that, again, myself, Rob, are here to address any questions that the commission may have. So thank you.
I did ask, Mr. Rule said there was a shadow analysis or daylight analysis in this presentation material packet. Is that part of this submission or no?
No, I think he answered that there was not a shadow.
I'm sorry, I misheard.
A shadow analysis. Okay. That's right.
Pardon me. All right, we will now hear from other individuals wishing to provide factual testimony concerning the request. As a reminder, witnesses should provide factual testimony as to how this project does or does not meet the applicable standards. The commission must base its decision upon evidence in the record, not personal preference or opinion. All right. Are there any members of the public wishing to speak? Or other parties? Yep. Sir, and before you begin, can I have you state your name, record, and address in relation to the case?
You're asking me?
Yes, sir.
Well, good afternoon, Mr. Chair and Commissioners. My name is Russ Stevenson. I live at 213 Oberlin Road in Raleigh.
All right. And do you swear or affirm that the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
So I'd like to begin by getting back to the architectural site plan. Okay, I'm sorry. I'm getting ahead of the game here, apparently.
May I just ask a couple of questions?
Well, and then, yeah, I'll leave it up, yeah. Thank you. And Mr. Stevenson, what do you currently do for employment?
I am currently retired, except that I am a member since 2024 of the Wake County Board of Adjustment.
Can you just briefly describe your background and training and expertise?
Sure. My education is I'm a summa cum laude graduate of NC State University. I have degrees from NC State in environmental design and architecture and in architecture, and I'm a lead accredited practitioner. Shall I go into experience? Yeah. Okay. I am retired now, but for 28 years, a licensed professional architect in North Carolina and in Maryland, working in the public and private sector, so between 1991 and 2019. I'm also a professional urban design consultant working in the public sector from Virginia to Georgia, again in the private sector, in the public sector, excuse me, for 12 years between 2006 and 2018. I probably have the honor of being the only person in the room here who actually has been a principal planner for an element of the...
Mr. Stevenson, I'm sorry to cut you off. One of our members needs a break. May we take a 5-minute recess? My apologies. Thank you. All right. Commission will break for 5 minutes and then reconvene.
All right, I'll go refill my water.
If you will, please resume, maybe begin back at the beginning of your experience.
Right, thank you. Once again, I'm retired now, but for 28 years was a professional licensed architect, licensed in North Carolina and Maryland, working in the public and private sectors. I'm also retired, but worked for 12 years as a professional urban design consultant, working in the public sector from Virginia down to Florida. I was also the principal planning consultant for an element of Raleigh's own 2030 comprehensive plan, the Stanhope Village area plan, which actually includes the John Kane building that when I later on council negotiated step backs and transparency for that building. I've served as an at-large Raleigh City Councilor from 2005 to 2019. And that was the time at which we were crafting the comp plan and the UDO. And I was the principal council contributor to the urban design elements in both the comp plan and the UDO. Incidentally, I'm also a retired North Carolina licensed general contractor between 1979 and 1990. The only award and acknowledgement that I'll focus on here is that during my time as an urban design consultant working for local governments in North Carolina and in other states, the consultant teams that I worked on won multiple North Carolina APA awards. That's it.
Okay, and Mr. Stevenson, have you ever been recognized as an expert in any legal proceeding, whether that's in court or this type of tribunal who does quasi-judicial evidentiary hearings?
Yes, I have. As a practicing architect in Raleigh, I have appeared before the Raleigh Board of Adjustment seeking variances for clients.
And I think this goes without saying, based on the experience and everything that you said, but you're familiar with the development and zoning regulations of the city of Raleigh, you know, specifically the building design standards that applies to this project in this case?
Yes, I am.
And then, again, just reiterate that you're familiar with the city's 2030 comp plan as it relates to the city's design standards?
Yes, I am.
At this time, I'd like to go ahead and I'm going to mark it, and I'm going to say that it's opposition exhibit 1. I'd like to go ahead and enter that into the record. And at the appropriate time, I would like to go and tender and ask the commission to accept him qualified in architecture and urban design, but I know Mr. Birch probably wanted to go in for it.
Right now. Okay. Did you have an exhibit that you were handing out?
Oh, just the resume.
Resume.
Yes, at this time, I'd offer and ask that this commission accept Mr. Stevenson as a qualified expert in the field of architecture and urban design.
All right. So noted.
All right, Mr. Stevenson, did you review the agenda materials and the applicant's design alternative application and the associated plans in ASR 2426?
Yes, I have.
And are you aware what the applicant is requesting from this commission on the design alternatives for this project as pertains to transparency and the building mass step back UDO requirements the applicant is seeking relief from?
Yes, I am.
And specifically the transparency requirements, which are in the staff report on pages 5 and 6, sections 1.59 and 3.26F. Are you familiar with those?
Yes, I am.
And can you briefly summarize the purpose and intent of the transparency requirements that are in the city's UDO?
Right. Well, to quote the intent statement, let's see, the transparency requirements are intended to lend visual interest to street-facing building facades for both pedestrians and building occupants. That's a key point, and minimize blank walls. What I'll say in general is, if I may, is that the UDO requirements for transparency in section 159 and 326F and stepbacks, section 333, exist for one reason, and that is to improve the public realm by promoting public street environments where buildings facing public streets provide a high level of engaging interaction between indoor and outdoor spaces with pedestrian amenities and adequate daylight in order to attract pedestrian activity. And that summary is borne out by the underpinning policy statements in the comprehensive plan, policy UD 4.5, urban design 4.5 for improving street environments, which speak to creating attractive and interesting commercial streetscapes by promoting ground level retail, minimizing curb cuts and driveways, and avoiding windowless facades, and comp plan urban design policy UD 4.6, activated public spaces, which call for providing areas to stimulate vibrant pedestrian street life and encourage the activation of such spaces through design of adjacent structures, for example, through the location of shop entrances, window displays, awnings, and outdoor dining areas. And so what I will say is my first reaction to this site plan, if I can get the site plan up here so we can look at it. Does anyone know how to flip forward and backward? There we go. Okay, now I've got this thing turned on, so I need that to go. I hit a button down here thinking that was somewhere down here is where well, it doesn't show up here anyway, so maybe that's okay.
Okay.
Okay, so let's back up here. So where is the full building? Okay, there it is. Now, so I believe it was Ms. Charlin said, you know, why is the building not oriented towards the public right-of-way? And that's the immediate question that came to my mind when I looked at this site plan, and that is all the utility functions are packed along Lassiter Mill Road. And what we've heard from the applicant is that the master plan dictated the orientation, which is to say the urban design guidelines and the Unified Development Ordinance regulations on transparency and step-backs did not dictate this orientation. Further on in the presentation, we heard that the design was driven by ownership and not by a UDO requirement. So, and then there was a lot of discussion about why we can't do this or we can't do that. But for our purposes today, we're here to talk about whether this building design and its treatments related to transparency and step-backs meets the UDO intent. And to the extent that the applicant has offered zero transparency along the Lassiter Mill frontage, which is the only public right-of-way in this building. They got 3 other frontages where they could do these activities. Suggests to me that they really were very focused on the internal organization according to their master plan and not trying to comply with the UDO requirements for transparency and step-backs. What I will say, so again, to go back to that original statement about transparency, it requires that street-facing building facades have visual interest for both pedestrians, people out on the sidewalk, and for building occupants, okay? There are no building occupants facing Lassiter Mill Road, and somehow the applicant has suggested, well, that absolves them from the need to have building occupants facing Lassiter Mill Road, and I think that's just completely unsupported by anything in the UDO. And I'll go even further. You think a lot of the discussion here about step-backs has been that they've carved this big C-shaped building instead of just a big flat monolith along Lassiter Mill Road. And it's true, they have done that. But the building massing regulations call for that when, let me get all the wording here. the design alternative building setback in lieu of step back, which is what they're asking for. They say we're moving the whole building back in the center, so we're asking not to be held to the step back requirement. But what the required finding says, the actual wording is that it creates a streetscape that includes pedestrian amenities such as seating areas, trees, and landscaping or outdoor dining. So in this case, the offset in the center of the building doesn't provide any of those amenities. It provides a loading zone for heavy equipment loading and for trash hauling. And of course, it's screened off with a little fin wall that has 2 industrial garage doors on there. We heard the applicant say, well, are you coming forward with your own alternate design? But of course, that is not our responsibility. Our responsibility is to say, does this project, with its lack of transparency and lack of step-back treatments along Lassiter Mill Road, does it achieve the objectives for creating that interaction between inside and outside spaces on the public street in a way that creates a vibrant urban environment, pedestrian urban environment here? And the answer is 2 big loading dock doors and some shrubs that are hiding blank walls is not the same as the intent that is detailed in the UDO for transparency and step backs.
So let's get right into it, Mr. Stevenson. You're aware of the 2 required findings as it pertains to the transparency relief that they're seeking in this case. One of which is whether it's consistent with the intent of the transparency requirements, which obviously you're very, very knowledgeable about, considering your experience with the UDO, not only in terms of formulating the comp plan, but also your experience on city council for those number of years. And then as well as the street-facing building facade utilizes other architectural, artistic, or landscape treatments to create visual interest to offset those reduction in transparency. So again, based on your experience in education and as well as your background, do you have an opinion as to whether or not the applicant's design alternative meets those standards?
Well, as far as I can tell, the design alternative for transparency is, what I've heard them say is, since there's no habitable spaces along Lassiter Mill Road, there's no reason for us to have any transparency. And so we'll just put up some shrubs, and that will satisfy the intent of the UDO for transparency, which, again, the intent statement is that the alternative is, well, the intent is to lend visual interest to street-facing building facades for both pedestrians and building occupants. The requirements for the ground floor, which is where streetscape activity is the most important for an active public realm, is on the ground floor. And the architect's drawings, tabulator data indicate there is zero transparency on the ground floor or the second floor of this building. In fact, no transparency, they say, all the way up to the 5th floor. So I'm very much focused on Lassiter Mill Road. It is the public right-of-way. The other frontages, that's all private realm. As far as I'm concerned, there may be some connection on the upper stories to windows that overlook I-440. But, I mean, that's, no one that I know of driving on 440 is going to be impacted by a UDO design that does not comply with transparency and with step-back requirements.
So based on that, in your professional opinion, has the applicant met their burden of proof of satisfying those 2 transparency standards?
No, they have not.
Okay. And, the applicant, provided justification on page 12 of the staff report in their application. And obviously, of these renderings that they, entered into the record, or I assume they entered into the record today, and based on, counsel for the applicant and as well as their architect, is there anything that you disagree with or raise red flags in their testimony besides what you already point out by some of the questions by this commission members?
Right. Near the end of his testimony, Mr. Birch said there are no amenity spaces provided along the Lassiter Mill frontage. And so I agree with that. But unfortunately, in seeking a design alternate for the building massing, they immediately run into finding 3 that says that the alternate design is going to include pedestrian amenities such as seating areas, trees, landscaping, or outdoor dining. So he said we have no amenities, but the finding number 3 requires to seek that alternate, you must have those amenities.
Well, I guess it would be a good segue into, let's go to the, the building mass standards.
Okay.
The UDO requires them the burden of proof to go and satisfy the 5 standards, I think that's set forth on page 13 in UDO 3.3.3D. So based on your experience and your professional opinion, or do you have an opinion as to whether or not they've satisfied some or all of those 5 standards in this case, based on their design alternative?
All right, I need to look at them because my focus has been on the required alternate findings, which are, there's 4 of them, and 2 of them I could say they could meet those, but they're required to meet all 4.
All 5.
All 5, and as it relates to finding number 2, which requires a design alternate that enhances the pedestrian environment. The alternate is setting the building back in lieu of stepping the building back in the center of the building. So it creates a big setback in the building. But does it create an enhanced pedestrian environment? Well, no, it doesn't, because it doesn't create this kind of pedestrian amenities, seating areas, and landscaping and outdoor dining. It creates a service yard for heavy loading and trash hauling. And it's screened off with 2 big industrial doors and some plantings. So I don't find that their design alternate meets the intent of the 5 findings.
Okay, and specifically, which ones are those? Is that finding number 2 and finding number 3?
Finding number 2 and finding number 3, I find that they do not, that the applicants pushing the center of the building back and putting a loading facility in there does not meet the requirements of enhancing the pedestrian environment or including pedestrian amenities such as seating areas, trees, or landscaping, or outdoor dining.
And again, they have, justification in the agenda packet in their application for why they go and meet those 5 standards. Based on that and all the testimony that was provided by their architect and counsel, is there anything that you disagree with in terms of what they said as pertains to building mass, or even go back to transparency?
Yeah. Well, once again, on transparency, sort of a circular logic to say we shouldn't be required to have transparency because there's no building occupants facing Lassiter Mill Road. Well, the only reason there's no building occupants facing Lassiter Mill Road in a way that could allow them to actually comply with the UDO requirements for transparency is if they put the active spaces on Lassiter Mill Road. And to say since they're not there, we shouldn't be required to deal with transparency in a substantive way. So it's very circular logic. In terms of massing, once again, they're requesting an alternate that allows them, instead of having a consistent step back across a frontage that goes all the way across the Lassiter Mill Road, they're asking to change the shape of the building to put a deep setback. And finding 3 speaks specifically to that deep setback. And it says when you provide a deep setback in lieu of a step back at a certain building height, it must create a streetscape that includes pedestrian and amenities such as seating areas, trees, and landscaping or outdoor dining. None of that is shown in their design.
So I think to summarize, and I'm going to use a little bit of what we do in the legal world, is some of their justification is conclusory, wouldn't you say?
Okay, for us non-lawyers, what does that mean?
That they're just reciting the standard and say that they meet it.
Right, exactly. Well, I've also studied the staff review comments for this project, and I'm a little bit surprised. One of my very first questions is, why are we coming asking for design alternates when we don't even have a final design? Staff has said these two commercial driveway entrances into this loading area are not compliant with the engineering standards for vehicular movements or sight lines to the adjacent side streets. And I'm wondering, well, what does that mean? Does it mean those things are going to have to move somewhere else and we're going to come back with a different design? Well, we don't know because they haven't satisfied staff's engineering concerns about the traffic safety issues, driveway spacing, sight lines to adjacent streets here. So I'm a little bit confused why we're granting design alternates for a site plan that has not been even fully approved by city staff. That's it.
So just to summarize, in your professional opinion, they have not met the two required findings, in your professional opinion, for the transparency. Is that correct?
Right. And I'll say they've asked for lots of alternates for transparency on different facades and different altitudes. The one that is the most important and that concerns me the most is that what happens at the street level along Lassiter Mill Road, which is the public right-of-way, which is governed by the UDO requirements for transparency and step backs. And in those areas, less important perhaps facing I-440, maybe less important facing the side of the Restoration Hardware building, but certainly along Lassiter Mill Road. I mean, that should have the potential to be a prime pedestrian street with streetscapes, sidewalk dining, all the things that make North Hills great, not just inside the shopping center, but outside, instead of turning all the utility functions back to the public right-of-way. I guess, there's a lot of discussion about ramping this way and that way, and they've not noted that there's actually, up above the site plan, there's actually an existing ramp already there that suggests to me there's many other ways, and I'm not going to design their project for them, but there's many other ways to get cars in and out of this this site and to locate utility functions that would comply with the comp plan requirements for making Lassiter Mill Road a very active and engaging street front where there's active uses in the building facing the street so that pedestrians going by can shop, dine, and sit outside and watch the world go by. But none of that's going to happen the way this design is done.
And I guess going to a question that was asked by a commission member on why it couldn't have been arranged as opposed to the ground level facade they're seeking a transparency reduction of, why the loading dock and the utilities couldn't go and be moved onto, was that North or Main Street at North Hills, right? So, and the answer to respond by the applicant was it was an ownership decision. So ultimately, it is plausible and in fact possible to go and do that in your professional opinion, right?
Yes, it is.
And switching gears, going to just in summary, in terms of the step back requirements, it's your professional opinion that they have not met all of the required 5 findings, specifically finding number 2 and number 3. Is that right?
That's correct.
So I'm just going to go and pause there briefly for a second in case you all have any questions for Mr. Stevenson. And also at this time, I'd like to go ahead and pass out. This is just a summary report from Mr. Stevenson that I want to, at this time, go ahead and formally enter into the record as Exhibit 2.
I just want to ask you to reiterate. It seems to me what you were saying was the transparency waivers and the massing waivers that are seemingly being requested here are quite contradictory. Is that what you were getting at?
I think they call them, to me, it really looks like a waiver, but that's not what it's called in the document. It's called a design alternate. And saying we're not going to have any windows doesn't sound like much of a design alternate when the rule says you got to have 50% transparency. It is a request for a waiver, so you're right.
Thank you.
Thank you.
Gotcha. Okay. No cross.
So I have one more witness that's going to go and testify. He's not an expert, but he's not going to give lay opinion testimony. He's just going to go and testify to factual evidence and as well as going to the intent behind some of these waivers of the transparency and building mass requirements. We'll go directly into the standards that you all need to go. So I'm going to call Larry Helfand.
Before you begin, for the record, can you please state your name, address, in relation to the case?
Larry Helfand, 1013 Thoreau Drive, Raleigh. I lived in Raleigh for 45 years. Current chairman of the Midtown Citizens Advisory Committee. And I've been involved with this rezoning for over 5 years.
And do you swear or affirm the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you.
And Mr. Helfand, did you provide a written statement with some photographs that you would like to testify to and also enter into the record?
Yes, I did. I have one here.
Just going to give at least a brief opportunity for Mr. Birch to go. Otherwise, I want to go into the record as soon as there's no objection.
Mr. Chair, I just want to register my objection to this. Again, not expert testimony, covers areas outside the scope of the commission's review, but I'm fine with him testifying. I just want to note that objection for the record.
Noted.
And I'll just say, too, to the extent of whether or not it's substantial competent material evidence to the standards before you, that's ultimately your all's decision.
You didn't ask, but yes, my background is a scientist. I'm a chemist, and I don't have any expertise in architecture. That's what we have an expert for. What I do have a lot of knowledge on is trying to do what's right for the neighborhood. I've been working with the Kane development since it started from a one-story building, open mall, to where it is today. And we've always tried to do what's best for the community, try to get buildings tiered down to be comparable to what's around it. And that makes a better development for both residents and for visitors and for those users of the mall. With that said, I'll try to get into my statement. One other thing, can we change the picture that's up here to the one that showed the attempt at the design alternate?
Left and right arrows on the keyboard.
Let's see. I'm not sure which one you want, but we can go to the one, that one right there. Okay. Again, not a professional, and we're going to talk about shade a little bit later. But if you look at this building the way it's designed right now, it's a 15-story building. Now, 15 stories, that's almost 200 feet high. And what they've created now is not one 15-story building, but the impression of two 15-story buildings looking out right across from the neighborhood. And on top of that, as was noted before, they're going to have an active loading dock on the first floor right across from the neighborhood. And with that preface, I'll get into the statement that I prepared. Thank you for allowing me to speak today. I have watched the North Hills Shopping Center go from an open area shopping experience of single-story buildings to the regional center that it is today, and its future is yet to be developed. The one constant neighborhood objective throughout the emergence of North Hills has been to ensure that the retail development takes into account the surrounding neighborhoods and the transitions down in height to the homes that are around this development. To that end, the Midtown Area Plan was developed to provide additional policies and land use recommendations, particularly for development along Lassiter Mill Road. These policies were incorporated into the 2030 Comprehensive Plan in 2020. While it may seem that this information is not germane to today's discussion, I'm bringing it to your attention because North Carolina law actually requires that the UDO be consistent with the Comprehensive Plan, but in Raleigh, there is a gap that has not been addressed. The Comprehensive Plan has the following provisions, and I'll just get into them briefly just to give you the idea of the lessening of the impact on the neighborhood, which is the intention. First of all, density transitions. When two areas designated for significantly different development intensity abut the future land use map, the implementing zoning should ensure that the appropriate transitions occur on the site with a higher intensity. In other words, we lost in the rezoning, but the intent was to have not a 15-story building, but to have a 4 or 5-story building that would face the neighborhood. We're dealing with what we have now after approved by council. Building height transitions. Again, any mixed use or non-residential use separated from an area of low or moderate density by an intervening street other than a major street, building faces along the frontage facing the residential area should not exceed 3 stories. Again, that's not what we have today. We have a 15-story building.
Mr. Chair, again, I'm going to object and try to ask that the commission keep the testimony focused on the alternates, all of these comprehensive plan policies, et cetera. While, yes, they were discussed in the context of the rezoning, we're through the rezoning. We're focused on the standards, the intent statements are in the UDO, et cetera. So we just object to the testimony outside of what's focused on the standards.
Yeah, the chair may make a determination on the objection.
Yeah, I tend to agree with the applicant's counsel on this matter. City council did kind of vote and decide on this. They kind of had the say on the overall
I understand. I'm
master
just
plan,
trying to set
but-
the tone for you, that's all. Just
Understand,
letting you
but,
know why people have been so aggravated over the cane development for the last 5 to 6 years.
Yes.
But I'm going to get to the nuts and bolts. I recognize what you're here for today.
Thank you.
And you're here for the two things, density massing, and you're also here for transparency. That's what I want. I'm going to address both of those.
Okay, thank you.
And for the amount of time that we have left, I'll try to get to them as quick as I can. What I did want to address in particular was the text change that you're dealing with today, which in reality turned out to be the massing statement that you're dealing with. The previous statement dealt with buildings that were 7 stories, well, that called for step backs that occurred after the 7th floor of a building. That was modified in 2019 to allow not for buildings up to 8 stories, but for buildings up to 13 stories or more. Because of this increase in height, it is now more imperative than ever that those step-back requirements be enforced to lessen the air, light, and shade impacts on the neighborhoods. And again, that was enacted and put in place in 2021, and that's what you're dealing with today. So therefore, it only leaves us two sections of the UDO to deal with, and that's what today's discussion is all about. The developer's proposed design alternate for transparency places the buildings back, which includes placing another loading dock facing Lassiter Mill that is completely inconsistent with the UDO. As noted previously, building massing regulations are required to mitigate the impact of tall buildings near a public right-of-way, Lassiter Mill Road, requiring step backs to avoid a canyon effect, which would limit access to light and air at street level and mitigate wind impacts. We've conducted shade studies. Nobody asked, people, you asked if the applicant had one. We have one. We've conducted it and showed it for the rezoning. But I put a picture in here. Now again, this is created, but since we don't have a building in place, and we only have the outline of a building that was going to be built.
Again, I would object to the inclusion and consideration of this. This was, one, prepared at the zoning stage. Two, doesn't take into account the actual building proposed. And so is not relevant to what we're building and the alternates we're discussing today.
Yep. With that being said, here is a picture of what the shade will probably look like when it impacts the neighborhood across the street. And I know you can't do anything about it. It's a 15-story building, and it's going to happen. But if you don't enforce the step backs, the impact is going to be more than what it could be. There is a reference in there for the full shade study. If you'd like to see it, it's posted out on YouTube. It turns out that this impact is not theory. This impact actually exists. If you go across to North Hills East and you walk up to where the Capitol Grill is and the AC Hotel is across the street, I don't care how sunny it is, I don't care how calm the wind is, you will always have a wind in your face as you walk up that street. It is constantly a shaded area, cooler temperatures, and it exists.
If I may, we are focused on the two matters at hand for the design alternate applicant.
Okay, let's come to the next picture I showed you. That's the Highlands. Highlands took a pretty good shot at trying to get the step back right. If you notice, at the 7th level, there's a significant step back across the building, similar to the design up here, with a space in the center with a little bit of a step back. It's a little bit of a setback. But look at the bottom of the building. These are active loading docks, active transportation docks, active delivery docks. That's what people see on the street. That's what impacted Ms. Ibrahim earlier. The next picture you'll see is an actual picture taken showing the hole in the ground, basically where the building is going to go. And you'll see the buildings as you approach further up the road. When this building is put in place, none of those buildings will be apparent as you drive up the road. What will be apparent is the impact that this building will have on the neighborhood across the street. What they shouldn't be forced to look at are loading docks, trash depots, trash on the street, and this can all be avoided if you would go ahead and enforce the transparency requirements that the UDO specifies. One last picture. I think the applicant said there's no activity currently on the street. Well, here's two pictures I threw into the presentation I have for you today. One shows a truck unloading on the street, and the other shows a truck waiting to make a delivery on the street. Why didn't they go into the garage? Well, probably because they couldn't get the truck into the garage at the time. They didn't want to wait to have to deliver their goods. So one last thing, and it's not in the presentation that you're looking at today. It's really important to get this building right. The city is about to invest a lot of money into Lassiter Mill Road to improve mobility. And when I say mobility, I mean walkability and bicycling. They're going to invest a lot of money that's going to have people walking up and down the street or riding up and down the street. If you allow this building to go up the way it is with a loading dock facing the street, you are defeating the purpose of what the city wants to invest in, because they want to improve the walkability of the city. Thank you. Oh, one last thing. Sorry about that. And I guess I should put this into evidence as well. Somebody asked about the staff report. And I was hoping to put this into evidence for only one statement. I'm just going to read you the statement because this is still unresolved in the site plan review. There are ongoing issues with the adjacent development on Lassiter Mill Road where loading vehicles are using bike lanes. Okay. I'm trying to save time. It's on the third page. Okay, I'll just read the statement for you. It's on the third page of the report. There are ongoing issues with the adjacent development on Lassiter Mill Road where loading vehicles are using the bike lanes instead of the designated loading area. How will this site prevent issues like this from occurring with this development now? I have spoken with fellow staff, and here is the direction needed here. Considering the longer-term interest along Lassiter Mill, a conversation about the streetscape is required. Staff has continued concerned about obstruction of bike lanes due to parking, solid waste, and other issues. It's important to get a 12 MUP, whatever the MUP is. I assume it's more space behind the curb. Please provide additional detail that demonstrates how vehicles will not park along the curb for unloading and loading and using the interior of the structure rather than parking on the street. And that's the challenge I think you should ask the applicant, because they should be able to take trucks in internally, do all the loading, do all the trash handling inside the building, and not have to burden the people across the street or walking by or biking by with that same inconvenience. Thank you.
Thank you, Mr. Helfand. Pat, is now an appropriate time to ask the applicant for rebuttal, or should I see if there are any other members of the public who wish to speak?
The latter first.
Okay.
Yes.
All right. Are there any other members of the public present who wishing to speak on the matter tonight? All right, hearing none. Apologies, please proceed.
I appreciate it. Great. So I want to touch on a number of those items, but we'll touch on the one that just, it's been raised relative to the loading and service area and the, what's been experienced at Highlands. And so we'll call up Jonathan Balderson with McAdams.
Mr. Balderson, before you begin, please state for the record your name, address, in relation to the case.
Yes, good evening. Jonathan Balderson. I work for a civil engineering firm here in Raleigh, McAdams, and we are at 621 Hillsborough Street in Raleigh, North Carolina.
All right. And do you swear or affirm the testimony you will provide will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Please proceed.
Jonathan, if you can give brief educational, professional background and your familiarity with the Raleigh UDO.
Sure. I received my undergraduate degree at Virginia Tech, and I'm a professional licensed engineer in the state of North Carolina. And I am familiar with the UDO.
Yeah, and you prepared the plan in review with the city?
I did.
Great. So you've heard comments about the loading and service area at the Highlands development, right? Feedback from the public in the city as well. And can you talk about how that's informed the design of this building?
Sure. Yeah, definitely worked a lot with staff and with the design team to address some of those concerns. The city has an ordinance that requires service vehicles and all vehicles to exit and enter the site in a forward motion. So the service area for this particular development is much more conducive to full movement of service and loading vehicles into the service area. So as we look at the Lassiter Mill entrance, there's there's truck movements in, and then the truck could move all the way in this direction, back up and then out. And then there's also an additional loading dock back in this area for this similar movement to happen. So just want to emphasize the amount of attention to detail to allow that movement to happen, and lessons learned from other projects such as the Highland.
Yeah. So I guess it is the size of this loading and service area provided as part of this development larger and more conducive to loading and service interior to the building?
Yeah, certainly much more conducive, especially for larger vehicles that are anticipated for the retail users of this project.
And then you also heard a question about, loading service off of Main at North Hills. Could you speak to, issues with that?
Yeah, so Mr. Birch mentioned earlier there's stem link that's required by the city transportation department to meet certain stem length requirements off the public right of way. So given the short distance of both of these frontages, it's not conducive to have a service area on that. I will add on the circle at North Hills, there's also grade constraints that limit that. It's a relatively steep slope, as I think Mr. Rule alluded to. You're dropping down a floor to get under the parking deck in this area relative to Lassiter Mill. So definitely dimensional constraints, but also grade and vertical constraints.
Thank you, Jonathan. Appreciate it. Any questions for Jonathan?
You mentioned there are multiple trucks that can fit in that loading area inside. Can you speak to how many trucks does the building anticipate to have at a time unloading things?
I don't know that we've studied a particular number of trucks. In this screen, you can see two are sitting in that space. Just an estimation. I would anticipate you could have another truck there and then another truck here, and still have the movement in this area for all of those vehicles.
Understanding that on the left side, I forget what that street is called. Main. Okay.
The street here?
Yes, thank you. The driveway spacing would have been prompted as a design alternate request. Did you study possibly extending some of the loading, maneuvering area, impeding more of the retail space as an attempt to sort of redistribute retail to the Lassiter Mill side and exit through the Main Street side?
Yeah, we studied a number of iterations, really due to the constraints of getting that vehicle, the loading and service vehicles back through the site was dimensionally constrained. So we looked at this movement here. That doesn't meet the spacing, so it would meet a design alternate request to get that large vehicle that's shown here back out and around and back out to Lassiter. Really, from a best practice standpoint, we felt that would entice those folks to actually park on Lassiter versus navigating all the way back through the development. So kind of where we landed is this iteration here that shows and provides the best access right off of Lassiter versus some of those other iterations.
Any other questions?
And again, that I just wanted to provide that to, again, point to why, from a loading service area, why that's being provided in the amount that it is. Again, Jonathan mentioned lessons learned from Highlands working with the city and ensuring that the area for turning movements as well as additional loading area is provided here. Again, that speaks to kind of, again, the area amount of loading and service. So want to speak to, I guess I'll touch on building massing first and some of the comments made. Actually, we'll stay here. So for building massing, they noted they felt like findings 2 and 3 were deficient, but I'm sure 1 as well. But want to touch on finding 3. It says if the alternate proposes a building setback, right? So setback occurs at the ground level. It's where the face of the building at the ground level, right? So yes, we're beyond the 5-foot building setback here, but our alternate request is not based on us providing even more building setback at the ground level, right? So like that finding 3, we're not even operating under. Our request doesn't seek to say, hey, approve our alternate because we're going to provide more area at the ground level. So that finding 3 is not applicable, right? Because we are not proposing a building setback behind the sidewalk in lieu of a required step back. So the building right next to us that's going up, they came and proposed, they got design alternates for building massing along Hargett and McDowell. Shear wall, I believe 17 stories tall. The basis for their alternate was instead of being at the right-of-way line, they were going to push the building back and kind of say, hey, that meets the intent because we're pushing the building back the whole way, right? So I just want to be clear, we're not even operating under that finding. And I, again, want to highlight that finding is the one that speaks to, resulting open space, again, if we were providing that additional area, that open space would include pedestrian amenities such as, right, seating areas, trees and landscaping, or outdoor dining. Again, that standard isn't applicable, but we'll just note that those are options, right? We are proposing trees and landscaping, but again, the standards that are applicable to our request are 1, 2, 4, and 5. So in response to comments from the public, from the commission, I want to ask Rob Rule to come up and speak to some things that we will propose in lieu of, again, in lieu of transparency, but essentially conditions of approval related to these requests, both along Lassiter and the side. You'll just touch on the.
Yeah. So for item number 2, for the alternate findings, the approved alternate uses an architectural base distinguishable from the building above that enhances the pedestrian environment through a change in material, fenestration, ornamentation, rhythm, or other sculpting of the base. And I would argue we're doing all of that, every bit of that. So you can look at the building from left to right, and you can see the base of the building has the deep reveals that I talked about, extra cornice lines that I talked about, going across intermittently. We've got ins and outs. You can see from the floor plan, you can see there are pilasters. There's ins and outs. You can see in the plan there's angled walls. There's ins and outs on both sides. One thing I did not mention before, probably should have, might have saved a little bit of consternation, is on the elevation you see in front of you, you see the two arched openings that are most dark in there. Those are actually the service entry areas. Those would have ornamental roll-down doors that would be operationally controlled, closed whenever they can be closed, and then only open when they need to be. That's the idea. And they would be framed out in a very classic way with the arch over, with a metal band across the top, and some nice details. That's different materials that we're breaking down there. Surrounding those is the green screen wall that we're proposing just on that angled part. You can see it noted on the plan, and you can see it illustrated in the elevation. To the left and the right of that, you'll also see some additional arched openings that I didn't explain it before, but in those openings there are glass walls below those that would actually, you can see in the plan, there's depth behind that glass on the left-hand side. On that one, we would actually propose doing a vitrine where you would actually have a programmed graphic, active, energetic element happening behind there with lighting, maybe even art program, maybe retail graphics and signage, but something that is really active on the left-hand side, breaking up that facade even further. On the right-hand side, unfortunately, those are required, like I mentioned before, we have a very small footprint to squeeze in all of the mechanical, electrical, fire protection, plumbing entries into the building. That's where it occurs. And so we don't have the depth to do a really great vitrine there, but we would put glass in there, and it would be spandrel glass that you can't see through because, once again, it's not active space behind there, so we wouldn't want to see in there. But there are changes of materials. So all those things, the rhythm, we're breaking that up, and the fenestration, we're breaking that up all across that entire facade, and we've got that layered landscaping in front of it with multiple layers of high, medium, and low landscaping, which you can see a graphic indication of that on the drawing. And then when we come around on 440, same thing here. Here we also, on the openings, the arched openings you see there, once again, I didn't mention before, that's glass. So we're changing the material. You can see in the plan we've got the bulb outs, what we call pilasters, articulation in the facade, the crown mold, the horizontal deep reveal striations at the base of the building. One of those glass elements we probably could put, or two of those actually, we could put vitrines as well in there and do lighting and graphics and other things there. The one on the far left we couldn't at the main electrical room, but a lot of variety. So I believe if you look through the list of those elements that are in that finding, we want to do them all. I mean, we agree with the UDO. We want to meet the intent of the UDO. And of course, the UDO naturally says that when you have a plan that sort of has some things that can't be resolved exactly, that's why they put the alternate findings in there. So we are complying with the alternate findings.
And Rob, we've gone over.
I have a question.
Oh, yeah, sorry. Please.
Sorry. Would you mind, just for my sanity, revisiting the massing standards 3.3.3b and bring up that diagram again where you redlined and circled the affected stories?
Okay, so.
And can you clarify where the step back is required per the UDO again?
Yep, I sure can.
Yeah, I can do it if you like. Yeah, I'd be happy to do that. So it has to be between the first and the 13th floor where you do the step back, 12 feet deep, right?
Yep.
Okay, so the allowable mass that I mentioned before is 20 stories, somewhere roughly about that point that I've redlined on the drawing right there. So that is the allowable by right. So somewhere between this point right here and that point right there, we have to step back this whole facade 12 feet.
Yeah.
And let's just say it's at the 13th floor. So that line that comes across, I'm drawing a little bit high, but we'd have to step that back right there. So that's not there, and this is minus 12 feet behind that. By right, that's what we have to do.
Minus 12 feet where?
So
Below that.
If this is zero, if that building is sitting on the ground at 0, meaning 0 feet, that's where it starts.
Yeah.
The top part has to be 12 feet behind that. Does that make sense?
Can you ignore the 20 floors? Because I know you're not going with 20 floors, you're only going with 15.
Sure.
And just
Yeah, so
explain that again. Yeah.
Yeah, so if we just did it on the building we have in front of us, then it would be maybe, let's call it somewhere right there. We would have to set this back 12 feet right there. This would come back like that, and that'd be set back like that. So the minus 12 would be where that dot is right there from the 0 point, which is there.
Okay. Sorry, can I say this out loud and have you help me through this?
Yeah.
Buildings of 13 or more stories are required to place a step back above the first floor or 25 feet, whichever is greater, but below the 13th floor.
Correct.
So your step back is not at the top, your step back is below.
To be clear, it can be anywhere in that zone right there. You can
Yeah.
put, the UDO allows you to do it anywhere between that first floor and the 13th floor.
And how tall does the step back have to be?
No requirement for the height of it. It's just
Except to
wherever
have
you
a
wherever you
single-
put it, it has to be 12 feet deep. That's the only specification, but it has to be between the first and the 13th floor.
Like you could take, you could take one floor
Uh-huh.
and pull it back?
Everything
No,
above that.
Once you make the step back,
Once
they
you make the
all
step
have to be
back,
step back past
you're
that.
committed.
I see, you're committed, that's right.
All right.
I get your question now. That's right.
Thank you very much.
That's right. Okay. And just to be clear,
Yeah.
we have to do it on both of these facades that hit the ground right there. There has to be a 12-foot step back there and on this side over there. So that is, if we took this mass and we did the 12-foot step back at the 13th floor, that's kind of what that mass would look like. Now, to be clear as well, in this center section where I put the X, that is a step back because the ground floor is out here. And I know it was described earlier by Mr. Stevenson, and I get it, but that from where the ground floor is out here, that is a very deep step back. It goes way beyond the 12 feet. It's 70 feet on the left side, it's 50 feet on the right side.
Yeah, I'm 100% with you
Okay,
now.
got it.
Thank you very much.
I have another question before you go. As far as the transparency goes and the treatments at the ground level, I know it may sound silly, but would you consider putting actual transparent glass where you've already accounted for spandrel glass into?
It's in mechanical rooms.
Yes,
We've been
I
asked to do it
understand that,
before, and I was
but-
with this group for the Lifetime Living Project, which we also had this very similar alternate findings for the Lifetime Project, and we described some of those spaces where we have the mechanical spaces, and there was the suggestion. I think there was deliberation with this group. We came back the following month, and we all decided that it probably wouldn't be the best thing because it really doesn't enhance the pedestrian experience to look into a cold dead space that's mechanical oriented type stuff. That was the finding there. That's all I'm saying. So we left it as spandrel glass.
Just thinking, as it contributes to a feeling of safety as you're a pedestrian, at dusk or evening, and I understand the vitrine would add a little light to the sidewalk, but that is also kind of inherently the purpose of the transparency in a condition like this, to give some sense of eyes on the street and activation and just thinking.
Yeah, I mean, I'd be fine to do that. I'm just wondering what eyes on the street. I mean, there's nobody in those spaces, right? I mean, there's nobody there.
I guess
There
I
are
can
people on the
imagine it,
streets.
but.
Sorry?
There are people on the street.
No, there's nobody
he's
inside
saying
the
that
space
there's nobody
looking out.
inside.
I think that's what she meant by eyes on the street. Is that what, I misinterpreted, I guess. Eyes on the street typically is people in the building looking out for safety. They're watching the pedestrians, right? There's nobody inside those mechanical spaces looking out, eyes on the street. It's just unoccupied space. I'm not against putting windows into that necessarily. I just don't know if that's a great urban solution, looking into mechanical rooms with clear glass, but
You can dress it up.
yeah.
It's something to look at.
On the corner of Main at North Hill Street and Lassiter Mill, like that being a dead corner space is an interesting choice to me, both from an ownership perspective and a
Right here.
UDO perspective. I'm curious if the service courtyard could shift so the trucks are pulling forward and backing up, but that corner space leading almost all the way up to your exit for your trucks could be activated. Are you with me?
Yeah, yeah.
That space right there.
Yeah.
That creates a problem.
Providing transparency from the street that could be lovely.
Well, if you recall, the way I'm describing it is that opening right there, we're trying to make that really active with a vitrine, right? You understand that? That's what we're trying to do there. To actually get retail space out to that corner, out that side, and we did look at that hard. Jonathan even talked about that.
Yeah.
It was something that when we did all the truck turning movements in the space to get it to work so that it worked well, we just couldn't get it to fit. We did try.
Yeah, okay, I'm glad to hear you tried something on that. You're welcome to speak to it if you're headed up here anyway.
Yeah, just to reiterate the point, the idea of, let me draw in here, the idea of this truck movement is that depth is needed, the width of that space is needed to get the truck movement all the way in, back here, and all the way out. So that was something we looked at closely with staff on the transportation side to get the service within this space and not out on the street, in the bike lane, in the public right-of-way. And then to punch the spacing, if we were to shift all of this, then we would have a design alternate for spacing from both of these streets. So the space of having the driveway into the space and out of the space was intentional to avoid that request as well, and to set this up to have the service area and entrance within the building.
Because why? So, you can come before us to seek various alternates to solve a problem. Can you speak to why you chose this instead of a driveway requirement? And I might be interested to know how staff felt about that or would feel about that.
Yeah, I think that would be a better question for staff, to be honest.
Okay. Yeah.
But if we were to limit this space, going back to the active corner, yeah, that would be great. The active corner here, we would get into a reversing motion back into the right-of-way, which is a big thing for transportation to avoid, especially given the pedestrian movement along Lassiter, sidewalk, bike movement. To have trucks backing out into the right-of-way is always a big concern that we try to avoid.
Okay. Thank you.
Any other questions on that specific item? Again, I just want to, Rob, there was a lot of talk about, again, from a massing standpoint, and we've spoken to it. We spoke to it in our application. You spoke to it here about what the intent of the building massing regulations are. But just in your professional opinion, do the alternates both for building massing and transparency, both on Lassiter and facing 440, do these proposed alternates meet the intent of those regulations?
They do.
Yeah.
Yeah, I mean, I could expound on that. I do believe the mass is broken. I mean, you can see here, the mass is broken down. It's not what we're doing on the other side of the building. You saw the rendering that we're facing North Hills with. It's more massive on that side, but that's the side that North Hills wants to have. This is the side outward facing. It is the more urban solution to break down the mass. I heard it was described as two buildings. Well, actually, that's a good thing. Breaking it down and having a courtyard. We haven't talked about it, but in between there's a great courtyard space in there. You can see the trees and other things that we're going to really make that a great outdoor space there. It feels part of the scale. It brings down that scale of where the humans are down to close to the street level, and breaking down the building with base, middle, and top. I mean, that is a very specific way that the alternate findings say that you can be allowed to meet the intent of the UDO. And we're doing that with a very classic design that feels very nice for the area. It's compatible, it's contextual, it's got great fenestration, and like I said, breaking down the corners with the outdoor rooms that we have at four corners, it's got the articulation I think that the UDO is looking for the alternate findings.
May I ask a question real quick? If you're a resident of that building, and if you want to get on Leicester Mill as a pedestrian, what's the path to get there?
So because of the way that the loading works on the 440 side, there's a whole floor of separation over there because that way that drive works. So it's you come out the front door and onto the drive that's built today, and then you walk around towards Restoration Hardware and come out that way.
Or you've got retail here as well, right?
Oh, that's
Right. And you're walking by the residents are walking by active windows the whole way till they get out to Leicester Mill.
Right. We got active uses, again, along this section of Main.
But she was talking about residents coming out.
Oh, yeah, right
That's
here.
right. That's the way.
Yeah.
So that's the only access in and out for residents
So when you say in and out, that's the way to get to Lassiter Mill the most expeditious way. There are other ways from within the parking. You can go down below, and there's ways to get through the existing parking deck to anywhere in the North Hills development. Lots of different ways.
Rob, again, you mentioned it before, but just in your professional opinion, does the proposed alternate create undue shadow impacts on surrounding streets or public spaces or amenity areas?
No, not when you compare it to what is allowable by right, and I understand the concern with shadows, I do. But by what you can do by right, this building mitigates that, and it does not create any undue shadows.
Great. And then again, just from a transparency standpoint, you've already speak to that it meets the intent. And again, you've gone through how the street-facing facades utilize other architectural treatments there. I didn't give you space to do this before, but if you could, please just give your educational, professional background and your familiarity with the UDO.
After the fact.
After
the fact. Yeah, I was educated at Georgia Tech, lived in Atlanta with my practice for the past 21 years, but I've worked in the Raleigh area for probably 30 years. From the time I was an intern architect, done work up here in the entire metro area, starting with the John Deere headquarters in Cary, worked on the MetLife development also in Cary, several projects for what used to be Wachovia Bank, and many others, including what I've already mentioned, including for DeWitt, the 1,000 Social project that's up near the Exchange. Hopefully I'll be in front of you for 2,000 Social soon, and we can do the bridge that connects the two. Wouldn't that be fun? And then the Lifetime Living project, and worked with the UDO here in Raleigh as well as many municipalities all over the country.
Great. And have you been accepted as an expert by the Design Review Commission before?
I have.
Great. And so, Mr. Chair, again, I would tender and ask that Mr. Rule be accepted as an expert in architecture. So, thank you.
Thank you.
Okay, thanks, Rob. I appreciate that. Again, just to make clear, we are willing to offer as conditions the vitrines mentioned by Rob, as well as the ornamentation of the service doors on Lassiter as well. So I just want to make sure that that offer is clear there. And you heard Rob say, again, on the window or the kind of archway in this area here, where we're proposing spandrel, that if there is an interest by the Design Review Commission for that to be glass, that's something that can be done. So again, I believe that I'll also offer that if the applicant is willing to install, 2 benches along Lassiter Mill Road, again, here, in this area here, it doesn't, again, make sense to have it here with the grade change, but even though not directly related to a finding, but again, applicant is willing to make that a condition as well.
Is there a proposed bus stop along Lassiter at this location?
So, Jonathan, transit, no. So that was a discussion. The future of transit along Lassiter and Six Forks is still a topic of discussion, and where those bus stops will be located. And the rezoning case requires coordination closer to Six Forks, where the city anticipated those bus stops.
Thank you.
Great. I think that's all from me.
Cool. Thank you again.
Thank you.
For presentation materials, commissioners, do you have any questions for the applicant or city staff before we take this matter to the table? Yes, please. Go ahead.
So, shall I just begin my, I'd like to start by, there was some question about whether required finding 3 on building massing was met or not, and whether there was actually at the ground level a setback or not a setback, where that, what's described in the plan as a service courtyard is. I have a question maybe for the architect, because the way I read the building section, there is a fin wall out along the sidewalk, but there is no roof on that service courtyard, which is to say there's a fin wall out there, but there's not a building there. It is a setback at the ground plane that is concealed by a fin wall with 2 industrial garage doors. And so if I read,
I can speak to it. The area is roofed.
doesn't show it roofed in the drawing here.
It's roofed. And again, just want to reiterate, we're not proposing an increased setback as a basis for our alternate.
Right.
So I just.
Okay, all right. So well, my comments were based on the site plan drawings, which show it's not roofed. So that's different. What I will say, though, is several things. One, in terms of transparency regulations, I mean, they have made the decision because of their own master plan internal design to orient all the transparency away from Lassiter Mill Road. And the intent statement of the transparency regulations is it will create the transparency that is 50% minimum along Lassiter Mill Road will create visual interest for street-facing building facades for both pedestrians and building occupants. So that clearly indicates that is intended to be habitable spaces along Lassiter Mill Road, and that 50% occupancy is the thing that's going to create that transparency. So the alternate that's being proposed related to the intent of the transparency requirements, I don't know how you can say we're going to have no transparency where the UDO says we're going to have half the whole frontage along the street transparent, and we're still going to meet the intent of the UDO. So that I don't understand at all. And the other thing that I noted, and it was discussed here with the engineering people, is that there's still an open discussion about the viability of having 2 commercial street cuts right there on Lassiter Mill Road, their proximity to each other, which doesn't comply with the UDO, and their proximity to sight lines for safety on the intersecting streets on either side of the building. And so it's just, to me, it seems very premature to be passing on some design alternates when we don't even know if those, if that arrangement of driveways it will even be permitted by the engineering staff that's still reviewing this and still has those items as unresolved in their review.
Mr. Stevenson, based on the applicant's rebuttal and now yours, is there anything that changes your opinion that the applicant has not met the required findings, at least as it pertains to transparency?
No.
And in fact, you even used the word in your report making it impossible to meet the intent due to the entirely too heavy loading, trash hauling, and commercial utility functions there on the Lassiter Mill Road frontage.
Right. Yes, and that difficulty is again, one of the very first questions by the commissioners was, why is this building turning its back to Lassiter Mill Road? What is? And the answer was, well, it serves our purposes. Doesn't really relate to complying with the UDO requirements for transparency. And of course, the applicant is working hard here to make you believe that zero transparency along Lassiter Mill Road is going to create this kind of desirable streetscape along there. But it's my professional opinion, a frontage with zero transparency, no active uses along the street, and some benches and shrubs is not going to create an active streetscape along Lassiter Mill Road.
Briefly touching on the building massing, in terms of whether or not it met finding number 2, has your opinion changed at all, whether or not the applicant has met that standard?
Once again, the proposed design alternate is dominated by blank walls, maybe some architectural treatments, but there's still blank walls, a large utility courtyard with industrial roll-up doors, flanked by some planting strips and shrubs. But this facade does not enhance the pedestrian environment as required by finding 2. Okay. Thank you.
Just want to resolve the driveway issue. That loading service driveway issue has been resolved. Those driveways are compliant and can be located there, are spaced appropriately, and the site triangle sightline issues have been resolved as well. So there are no outstanding comments or issues related to that from a code standpoint. So want to touch on that, and then just reiterate, there is no active use requirement. Again, there's not an urban frontage district applicable to this property. Again, that was intentional through the rezoning process, knowing how this building was going to need to be served from a loading and service standpoint, right? When they went through the rezoning, right, the parameters of this property and access, et cetera, had already been established. So just want to reiterate, no active use requirement there. So thanks.
Thank you again, Mr. Birch. Commissioners, do you have any questions for the applicant or staff before we table the matter? Go ahead.
I'd just like to clarify what you just said about the rezoning, if you don't mind. So this is more probably for the record, but I want you to clarify it. So the rezoning did not require you to have an active use component or an urbage frontage requirement, correct?
Correct.
The rezoning did not permit you to avoid UDO requirements, correct?
Correct, right.
Okay.
Because we can't do anything at the rezoning stage we can't do anything less restrictive than the code at the rezoning stage, knowing that there's this built-in design alternate process at the site plan stage.
Okay, thank you for saying that. I think it's a little misleading to say that you have no active use requirement.
Understood. I guess what I'm saying is compliance with transparency doesn't necessarily require there to be active uses beyond that transparency area. And I was getting to the intent of, well, from a rezoning standpoint, that because of how the parameters of this site had been established during phase 1, that we knew we could not commit to an active use requirement or an urban frontage there because we knew we could not, at that time, 1, comply with an active use along Lassiter. So,
yeah. Thank you for clarifying that.
Any other questions, commissioners? All right. Hearing no additional questions or presentation of relevant facts, the commission will now close the hearing and bring the matter to the table. As a reminder, this commission is tasked with deciding if, based on the evidence presented, the proposal meets the applicable standards. This decision cannot be based on the personal preference of the commission members. Rather, it's based upon standards and evidence. If based on its deliberations, the commission requires additional evidence, the commission will reopen the hearing.
Chair Springer, if I may,
Please.
if I could interject 2 items for the commission. First of all, Mr. Halfant's testimony. It was non-expert opinion test evidence that was provided. North Carolina law treats that as conclusively incompetent. Ms. Ibrahim's counsel did not argue otherwise. So you cannot rely on that evidence in your decision-making. Secondly, I would suggest to the commission that when you reach the point of parsing through the findings, that you articulate the requirement for each one and your finding, your determination on each of the findings seriatim, one after another.
Okay. Thank you for that.
That was from Mr. Halfant. Yes. It was, yes. You can, that's correct. This was opinion testimony. It was in support of opinion testimony. That's how I would answer that.
All right. So we've heard a lot of points made to this. I think for us as a commission, it's important to remember we're tasked with two questions at hand, relating one to the transparency, lack thereof, and then the building massing. I think following the guidance of city attorney, it might be prudent for us to kind of go through this matter by matter. I propose we start with transparency. I'm happy to kind of start that discussion, but I also value your opinions very much, so I will open the floor to anybody that wants to kick that off. Anybody chomping at the bit?
Yeah. Casey, can you help us get the findings on the transparency?
What slide did you want? The findings?
Findings.
Yeah, transparency findings. Thank you.
I think with, sorry to cut you off, please go.
Oh, well, I was just going to say, the fact that it is a backside to the building, the renderings did make more obvious the effort that was made to break down that facade and give more visual interest on the street as a pedestrian, whether you're an occupant or not. I think what we did not inquire about was landscaping species and things like that that often come up in terms of their height and fullness. But regardless, I think the attempts made to get trucks into the building and not, just kind of creating the disturbance there is also part of that visual interest. Appreciate that. I would, I guess, like to ask if anyone else on this commission is in support of making a condition about a little bit more of a transparency of glass, even if it's just on the 440 side into the drive aisle, because I don't see a reason you wouldn't put transparency there. I think it's a healthy debate in terms of design, whether putting mechanical spaces on display could be interesting. But I do think that it helps support when everything on that facade is, uninhabited, as well as everything down the street, and that's not what we're looking at. But in terms of just generating a feeling of I can be here as a pedestrian and I'm safe to be here, whether there's someone working in that space or not, just seeing the activity would go a little bit.
My concern with at least the Leicester Mill side of things was if we made those glasses transparent, it's not necessary that there is light coming through or you're actually seeing anything.
You'd need an
You're
interior
just
design
seeing another
response there as well.
Yeah. So that was my, it's one thing to just see the mechanical spaces, but it's not really adding value in terms of light and what do you expect to get out of transparency? That was my concern. It's like, is there any benefit of even pushing on that? So,
But I think if you take that stance, you enter into the question of, okay, well, what do you do instead?
Yeah.
And I feel like all the options have been explored, albeit maybe not satisfactory. It's just really hard to move that space.
yeah. That's true, yeah.
Lassiter Mill feels like an opportunity to provide interesting, warm, welcoming, transparent space. And it does not seem to me that the burden of proof for why it is not possible to provide any % of transparency has been met. So I would encourage the applicant, if they were taking another look at things, to see if there were a creative way to provide some transparency that gives warmth, safety to that street front. It could be that that is transparency into a mechanical space where what you see inside is thoughtfully designed. So in the first 1.5 feet, 2 feet of that mechanical space, is there a way to put something in there that is interesting visually to someone who's walking along the street, to provide warm and welcoming lighting so that that feels safe to someone who's walking from Currituck over across and trying to get into the North Hills core? Does that resonate?
Yeah, I think
Absolutely.
Yeah.
It's just really tough with that space entirely because then you get into arguments about, okay, what can go there?
And safety with the trucks going in
Exactly.
and out.
And the partitions between those spaces do have a fire rating usually required with them, which can really detract from the attractiveness. I do think I heard the applicant, we can ask when we reopen, did allude to installing, I'm drawing a blank at the name of that, but that kind of deeper light lit window.
Yeah.
Also kind of mirroring that move closer to the turn down ramp there on the south side of the site, which I think could maybe help alleviate that. I think they've got along Six Forks some similar instances of like that type of application used for public art installations that do rotate. And maybe this is an opportunity for them to do that facing the neighborhood here that then can kind of help soften visually, the utilitarian nature of this level of the building.
And anything that might provide an art opportunity would also potentially be a pedestrian draw. So if you are in the core of North Hills and you know or have heard that there's an interesting rotating art installation or something, I mean, not here to prescribe what that is, but that is full of light and is warm and welcoming and draws people in. Like if you can get people out of that, in this area of Lassiter Mill, it feels like it would be a disservice to the future of the city and the future of Lassiter Mill, which maybe we need to hear from city staff about the future of Lassiter Mill. There was something in here about future plans for Lassiter Mill that would be interesting to know, because I know you guys will have bike requirements and things like that, and are there going to be new bike lanes, and that
Might be mistaken.
might be too
but
far.
Well, I think that kind of fell under some of the presentation that was more speculative in nature.
More speculative, yeah.
Not
Yeah.
something that we can really.
So I don't know if anyone wants to elaborate on that, but I think some effort or some attempt at more than zero would be much appreciated. If if 50% isn't possible because this is the most elegant solution for trucks coming in and out. There's also a water fire pump room, a generator room, an emergency electric room, and a main electric room that are also quite visible. In addition to, I'm still very interested in that, the corner of Main and North Hill Street and Lassiter Mill, and any creativity there would be welcomed.
My feeling on this is that what the group is talking about right now is addressing number 2. And those are kind of finer grained details to some degree. Whereas I haven't heard any of the fellow commissioners here, myself, take on number 1, which is really has the burden of proof that there is the public way is Lassiter Mill. And it seems pretty clear in the UDO that that frontage has a transparency requirement. And I'm just not quite able to square the two right now. I mean, I think there's a solution there for number 2, but you have to get through answering number 1 to get there. And I haven't heard that in a compelling way yet. I've actually heard from Mr. Stevenson's testimony that kind of begs the question, has this scratched the standard?
I want to make a comment that I think, to me, the idea of the transparency, the intent behind it is engagement with the community. It's not just, decoration. It's not just reflection. And I think that's what's the challenge for me, to see how any of what has been addressed on Lassiter Mill is addressing any engagement beyond, vehicular and deliveries, right? Which is not about the community, and it's not about that street.
And how would you do that with the usage that's there? And
I
think that's what
I don't
you were
have that
intending.
answer.
Yeah,
I don't
without
have that answer.
discussing
I don't
other
know that
options
that's
for that. I don't
our
think-
our
It's not
role
burden. Yeah.
to figure that out.
Yeah.
And that wouldn't be the point. I'm not suggesting anything. In my comment, I was simply saying we don't know enough, and we just have no ability in order to move it around
Right.
and make it transparent.
Right. But I agree that's sort of fundamentally sort of the start of this conversation.
I think I don't know, feel like we have a similar stance on that first one, transparency one, so yeah.
So maybe this is a conversation about both, and maybe there's probably a more unanimous decision on
Yeah.
those two.
Do we want to look at other findings?
Were you going to say something?
I was going to say those were, go ahead, Kat.
Well, I guess where I kind of feel is that we've been shown that you have transparency on the opposite side. The other two sides, they're too small for anything with the trucks to move the freight around. So therefore, by process of elimination, this is where we're at. And that's it. And so then we look at, like number 1 is like, it's too overwhelming to think like that's, okay, well, we just go to number 2 because, well, this is what we're kind of stuck with. But I guess the question is are we stuck with it or not? I live over in this area. I go down Lassiter Mill Road all the time. The truck is an issue. People do stop in the middle of the road. It's only getting worse with people, with the number of apartments and things like that coming in. And then the whole street itself, the other 2 buildings don't have any access. So this is the only place. I mean, is it going to be that there's 3 buildings and all of them just kind of shuffle down and say like, okay, well, that's it. It's the truck entrance and that's it. And it is the biggest road. So it just, and I can walk there too. So I wouldn't want to walk down that street. There's nothing to walk to from on this side at all. So
I would add that I believe this commission's purview is related to the public streets. And so the hardship of the internal ecosystem is not relevant. So, like, what we want to see on the public street is what we're here to talk about, or what is required on the public street is what we're here to talk about. The hardship of putting where to put the trucks in and out should be a private matter. It's not it's not necessary that has to fall on a city street to bear that requirement.
Yeah, I think some case was made. I don't know how convincing it was, but, along that kind of entry you would take down into the target, that would kind of go, there are grade challenges there that would prohibit that. I don't know what the kind of the main, is that Main at North Hills? That appears to be a rather tight street, so maybe that was a constraint that, as they were doing their turning radius study, like, this really was kind of the only apparent path that met some of the design criteria from the client.
But were those internal streets evaluated with the same criteria as those internal streets were not necessarily evaluated by the?
Yeah, I would add to that there was reluctancy to seek a design alternate because they would use that cross section, or whatever it is, Main at North Hills,
right,
where you could have sought a design alternate and prevented a lot of this heartache.
By using an internal site resource.
I mean, you still enter, or realistically, I don't know, something from Lassiter Mills, but I don't know, maybe I could have more of compassion for that because there was an effort put in, whereas it feels like these are waivers or exemptions to the UDO rather than like an effort put in.
For some amount of transparency,
right.
We can solve the problem.
Or at least try.
Or solve the problem lots of different ways.
Do we think then the transparency is sort of the give point for people, because we're looking at two different exceptions, so is the massing better, so much better, having a large space and gap and having air more around the building, is that like a better thing to have? And then at the cost of the transparency, because I think we're not in a win-win anywhere. So,
should we talk about the massing a little bit?
Yeah, so I think maybe we could weigh the two of them and figure out.
I think we should, we should
I don't know what other
Can you pull up the massing findings?
I think it's the next slide.
Thank you.
Yep.
Can I throw out immediately that I think 5 is off the table, just because it doesn't, there was no study, and we just have nothing on it?
Nothing was presented to us, yeah.
What do you mean by it's off the table?
As in, we just
Does not
received
mean-
nothing on it, so we can't evaluate it. Or
That's
I
the
guess-
one I wish, it's not hard to do a shade study, and I think it might have even served the applicant to do so.
Yeah.
Because now we can't
I think
determine whether or not that is actually impacting the street.
And there was a comment made that if it were done, it would prove that there's no impact.
And we don't know.
And we don't.
We don't know, yeah.
Yeah.
I don't know what the proper path is, but I think as a requirement for future building massing design alternate requests, especially as it relates to the step back requirements, that should almost be a required exhibit presented. But
Do we ever make conditions of our findings to say if we were to approve that upon receiving that shade study and finding it to support this?
Yeah, I think more appropriately in this case, and Pat, please correct me if I'm wrong, we have maybe encouraged the applicant to seek a continuance, and they bring those materials to kind of further build their case.
I feel like 5 was satisfied with the testimony related to the rezoning and what could be built here. So what could be built here is a 20-story building that would have a setback somewhere before the 13th floor that would then go to the top, that would create even more of a shadow than the building that they're proposing. So to me, this 5 is irrelevant. The shadow could be way worse than it is, and I don't see how a study would.
We can't confirm that.
It would be
without a
conclusive,
study.
though. I think we would need to see a study to call that.
Agreed. I also think that it would be helpful to see that study done in such a way that, so again, I'm going to come back to number 1 on this because I don't feel like it's been fully kind of talked through or addressed. And I think we heard during the presentations that, yes, if you were to strictly apply the massing rules, that you would need to, at the 13th floor or wherever it was, push back 12 feet. So I think it would be important as part of that shadow study to understand what that move would do to the shadow versus the way it is proposed right now, seeking relief from that setback.
I know we've had cases before us prior where the applicant came with the prescriptive UDO kind of shadow study, and then they're proposed, and it's really been super informative and something I think would really help kind of tell the story here as far as it relates to the shadows.
The way this is written, though, does not, I mean, it's public spaces, amenity areas, and surrounding streets. So
Aren't streets public spaces?
does this, right, but, I mean, we could, would the building throwing a shadow on the surrounding street, amenity area, and public spaces have a negative?
I think some of this too might be catered towards a more urban setting where you've got taller buildings on both sides of the street and you're trying to maintain access to light and air throughout the day. This is a unique kind of condition regarding that, but I do think for the benefit of us as we think about the neighboring properties, it would be good to understand, the extremes of the shadow kind of at the summer and winter solstices, and then maybe even the equinoxes, just kind of get an idea of what that range of shadow effect is going to be on Lassiter Mill and the adjacent properties.
I would add that I would have less of a concern about the shadow if the transparency requirements were being met. Like an undue shadow in an urban, I mean, I don't really know how we pick that apart.
What about the discussion that started this with the neighbor who lives across the street who's going to be significantly impacted by the shadow? I mean, to me, that's...
But are they?
Well, I wish we knew.
I know, but we don't.
Are you arguing that because intent is not satisfied in both transparency and massing, that we just need a complete continuation?
That's how I kind of feel personally. I don't know how the rest of you feel, but I think, there is a data point here that everybody wants to see and understand to make an informed decision, and that would be the shadow studies. And it's a fairly conventional document that I think, Kyle, you mentioned. You go, with the 4 times it's spring, summer, winter, fall. Yeah. And, fall and spring are kind of the same thing. So it's really just 3.
Yeah.
And you could do that for, the 21 stories and kind of just build the massing block. I think that's probably good. The applicant was, really wanted us to understand what that looks like. And I understood from the sketch, but it'd be great to see it in an exhibit, as would be an exhibit that showed what they're proposing now versus what it would look like if the UDO layer was applied to it as well.
Yeah.
that they are seeking relief from?
I think for finding 4, we heard mostly about reducing the visual scale of the building and less about mitigating wind impacts, which might be minimal given that there isn't another tall building across the street, but the increasing light at pedestrian level could probably also use a little bit more evidence for us to weigh in on.
I think its overall orientation is probably somewhat beneficial, being as Lassiter Mill is kind of on the western side, so as the sun kind of moves across during the day, I would say, mid-afternoon till the end of the day, it's probably getting a fair amount of sun. I do like what's proposed here. I do think a real attempt was made to be considered about the scale of the materials at street level, addressing some of these pedestrian concerns that the UDO raises. Again, I kind of go back to the transparency thing with everybody else. You're really in between a rock and a hard place to make this building perform from an operational standpoint and provide, standards of living that I'd imagine I don't know if these are apartments or condos, but those residents would seek to have. I think there, maybe some operational things the building owner could do, as far as limiting the hours for trash pickup and, overall building deliveries. I'd got no idea what the retail space may take, what, the hours of operation may be, but, maybe there's some middle ground, again, from that operation standpoint that could be reached to, make something of an olive branch to the neighbors across Lassiter Mill to, minimize disruptions to their daily life and not make this a real point of contentions for everybody.
I think they've satisfied number 2. I think the building is very pretty.
Mm-hmm.
From the second floor up.
Third, fourth.
Fourth floor up. Like I love the materiality. I love the trees. I love seeing the green on the kind of on that like roof cut back. I think that is all really well done, and the way the building kind of undulates, I think, is really interesting. And so, from that perspective,
If I may say this, the second one, it says architectural base distinguishable from the building about that enhances the pedestrian environment through a change in material and all that. So it's very focused on pedestrian environment, not necessarily just.
Which
what
goes
we
back
see
to
for the building.
transparency.
Yeah.
Which is why I would say
which
if
everything comes back to the
if
transparency.
transparency is satisfied, then this
We're
is
going in
satisfied.
But like pedestrian in the sense that I think of pedestrians as people on the other side of the street, as people driving up and down the street, as
But
people
what
on that,
level
not
are
just
they?
necessarily right next to the building. And I do think that this is it's a pretty building,
That's fair to say.
well designed,
Yeah.
above the transparency issue.
So been
It is a
little-
beautiful building.
Yeah, it's been a while since we've had to kind of address parking deck features as a commission. And I will say, this is a rather elegant solution to a lot of those problems. I know they're probably pretty early in design. I am curious as to what the screening material they're proposing to kind of infill at levels 2, 3, or 4, whatever that is, and what they would do to kind of mitigate the headlights washing across. I think maybe to the benefit of the neighbors next door.
Yeah, I don't know that I should
rise.
have been corrected about above the first floor, because I also like the parking structure.
Yeah, so I do want to commend
So
the
I
designers on
maintain
that.
above the first floor. I'm good. I like the building.
Yeah, and it doesn't really sound like we might be at a point to necessarily want to vote this without, opening this back up, asking some additional questions.
Do you
of the
want to go
applicant.
through the findings, the other findings? Is there like a setback findings? Or
This
was it only
is-
2?
This is all of
Okay,
it.
sorry, this is all, sorry.
Yeah,
The
those are-
transparency
Then it
is
should
the
be
other one,
good,
and there's
yeah.
just 2.
With that, the commission reopens the hearing. I don't know if you want to address any of the points you heard before we ask direct questions, or?
So what I hear is that it would be beneficial to see a shade study, and that is something that we can absolutely provide between now and the next, we'll have that ready for the next hearing. And on the solstices, equinoxes, and the comparison, right, between what's proposed and what could be done under the UDO. So we can provide that. And we can also, what we will also do is provide some additional detail on, the Lassiter and call it 440 side at the ground level in terms of, again, providing a little more detail, clarity around that. I want to maybe set expectations for that. Again, given how much has gone into arriving at the design that they are at, and particularly in terms of the loading and service area, again, being responsive to the issues that have been experienced at the Highlands, given, yes, the phase one, how it's set up things, and maybe we can speak to more about why going through the building and taking that left on Main back out to Lassiter doesn't work, even if we did have to get an alternate. We can speak to that, but for that mechanical room near the corner of Lassiter and the entrance there, we can provide some additional detail there, whether it's a vitrine or something, just views into that mechanical area. But we hear what the desire is, right, what the ask is. I don't want to set unrealistic expectations that we're coming back with
A complete redesign.
Correct. I'll just say the loading and service area largely is where it has to be. And so, but I think we can provide you all with some more detail and certainty on the fenestration of the roll doors and those other archways. So, and design team's incredibly creative, so maybe they'll come up with something between now and then.
Can I ask a question while I have you? In regards to what you just said, I mean, is it safe to assume that you've never really looked at having the loading dock on the inside of the property on the north? I mean, I know how it would look. I go to North Hills all the time, and I understand the visual expectation and the flow of that area. I get that, but I'm just curious to see if you have even considered.
They did.
Okay.
And again, there's that established drive on the parking deck that's limited in width.
Gotcha.
And then there's that turnaround. There's part of that is there's an exit down the deck, right? So it's not as if that whole thing can be reconfigured and getting trucks out into the internal area. I think you also heard Jonathan say that they looked at access, largely out of the building onto Main. And again, the size of that street, narrowness, where that would need to be located, you'd have those trucks having a hard time making a left as cars were coming in off of Lassiter, because there folks can take a left and a right off of Lassiter onto that Main at North Hills. And so you'd have a situation where, right, trucks would be taking a very tight left, very close to that intersection. And then they also looked at the reverse movement, right, which would reduce the scope of that area. But again, I think that's a worst case scenario where you have trucks reversing into Lassiter Mill Road with the level of cars there. So
Was that parking deck and drive, were those part of phase one?
yes, yeah. All that was part of phase one.
Okay. Did you consider what was happening in phase two when you designed phase one?
Yes, and again, the building that was on, originally part of the phase one plan that was pulled out kind of towards the end was oriented like the one is proposed here. I mean, it was dependent on or based on the internal street network and how all of that was designed as part of the phase one.
And so you submitted a site plan for phase two as part of phase one?
initially, there was a building shown where, what is now the Phase 2 area was initially part of the Phase 1 site plan.
Okay, that showed ingress and egress of trucks and,
I don't know if it got that far before it was pulled out, Jonathan.
The building was included in a site plan, ASR and SPR, and there was not a service. The configuration of the building was a different configuration, different use. It was not included in that proposal, similar to this configuration.
okay, so is it safe to say that the ingress and egress of your mechanical and service were not considered when you permitted and built Phase 1?
No, it was a different configuration, and I will say I was not the engineer on that project.
Okay.
So I've seen some of the older plans, but some of this is beyond my involvement.
So there's like a different intention for the building at that time, and maybe it would have fit into the plans.
Yeah, different configuration, different uses, different design.
Okay. That's unfortunate that that couldn't have been taken into consideration at the time that was built.
Yeah.
But
Even
I hear
after
you.
that was approved, they went and sought the zoning change, so
Right.
market forces, for whatever reasons, have kind of changed the approach, so.
Right. Yeah.
I think, too, in the materials that it sounds like you're planning to ask for a continuance.
Yes, yep.
A site section or something that kind of maybe better illustrates some of those constraints that drove the decision, or, why the loading zone landed where it is, I think could be very beneficial in trying to help illustrate to the rest of the commission
That would be very
some of
helpful
the
to know,
decision
yeah.
process. I can fully appreciate how difficult it can be to come before us and show us where you are, and maybe not the entire journey. So any additional kind of drawings, diagrams like that can help tell the story, I think would be encouraged in future submissions. All right. So since you're going to
So
request the
if you want us
continuance.
to make a formal request for, yes, a deferral to the next DRC meeting.
But we would like to kind of thank you, architects, designers, also the other party for coming and expressing.
Are you guys continuing this?
Yes.
So they can get a second bite at the apple, I guess? Is that what's happening here?
It is how the commission has operated in the past when we don't feel like we've got enough information to fully vote on the materials before us. So it's less a second bite at the apple and seeking clarification and additional exhibits that are not party.
But since that we're a party, I'm out of the state. If your next meeting's August 20th, I cannot do it.
It is not that our QJ hearings are the first Thursday of the month, so that'll be September 3rd.
Third. Is that close to Labor Day or?
It's just before.
That's, okay, yeah.
So
we should do it
September 3rd would be our next quasi-judicial hearing.
And are we going to be getting the materials, since we're a party, earlier than we otherwise would have?
I am less familiar with that.
And I'm only asking these are more logistical questions, but it does change a lot that we're just like the applicant, and I get it, it's their plans and that type of thing.
Yeah.
You'd have to do the same work, too.
Just public notice, and I guess I can work with the attorney on that as well, whether through city staff.
First, getting back to the continuance, the commission should make it clear, and the applicant should acknowledge that this is a voluntary continuance on the applicant's behalf at the applicant's request. Mr. Birch?
Yes, this is a voluntary request for a continuance to the meeting on the first Thursday in September.
And in terms of the request about having materials sooner, due process requires fairness here, and that party should have an opportunity to review and consider the plans that come in. So perhaps there could be some sort of agreement to a schedule, of submission.
I'd almost say that it should be pushed out to October or something, and that we get the materials in plenty of time in advance. I'm just making a suggestion. Again, things are, dynamic changes a little bit now that we have equal, due process rights as the applicant does, and certainly understand the commission not to go and continue voluntarily saying so. But
You could put the question to the applicant.
Yeah, I would say October is kind of not acceptable to us. I think I respect what Mr. Herman's saying, and we can certainly, again, what I hear from our team is certainly on the shade study front, that's something that can be done quickly. Again, the agenda items are typically posted online, 10 days in advance.
that's when I got retained, was exactly 10 days, and, here we are. And I just feel like, again, a little bit more time would be appreciated on our end, and we're doing the best case that we can with 10 days notice, right? So.
I understand. We would ask that we be scheduled for that Thursday, first Thursday in September. We will, again, we're not trying to hamstring and don't want to withhold information from them. We will, provide that information in advance, particularly the shade study.
And this isn't just convenient, but my expert just checked his schedule. He's going to be out of the country on September 3rd.
I'll be back in the first Thursday in October.
Convenient.
We
Can we make a decision? How does this?
It's their burden too, so if they don't have enough information if you want to make a decision, then that right there answers the question.
Right. I mean, I think the practice of the Design Review Commission has been, if y'all aren't ready to vote today, you've provided feedback, you've made requests of us for additional information. You all typically get that 10 days in advance as the decision-making body. So I think that gives us enough time and gives, them the same amount of notice that way. So we would, I hear that one of their folks are out of town, but again, we're wanting to be responsive to y'all, but a 2-month delay is substantial.
You can also request that we vote now.
Well, no, I think we want to be responsive to y'all's request and provide the information that y'all have asked for.
They did ask for the continuance. Is the expert testimony allowed to be submitted via affidavit if the expert is absent? Is there some working middle ground there? I know he wouldn't maybe be able to be asked questions directly by the applicant, but he would presumably be able to review the materials kind of in that 10-day window and provide, his expert opinion on what is submitted.
The challenge with an affidavit is cross-examination. I would not recommend that. And yes, to answer your question, you can make a decision. Somebody's going to be unhappy. Yeah.
We could put it to a vote.
Well, I was going to say, I will not be with you guys any longer to deal with the fallout of this, so I don't want to be the lone decider here, so.
Yeah, and just so y'all know, we're still in the ASR process, right? Like from okay, what does the denial accomplish, right? We're still in the ASR process. We would be coming back, I think, with similar materials and information. And so, again, would ask for you all to defer it, receive the additional information. And
they can always withdraw their application. That's another option before rendering a decision. Once you render a decision, is there substantial change in your next application? Because there's raised judicata principles that apply. You guys act as like a court of law, so they can't bring the same thing back twice.
right. Yeah. So, again, I think it's been the practice of this commission appreciate all the feedback that we've received. We want to be responsive to you all, including some information like the shade study in more detail. We are asking for a voluntary continuance and would ask that you not make a decision that's going to, again, put us back before you all, again, in the future, further down the road. I think let's keep this conversation going. And yeah, that would be our ask.
Thank you.
Kyle, I think we should plan to hear it in September. And as we have, this is just my opinion, as we have demonstrated, if we feel like we are missing information, then we can have that conversation at that time. Are we required to have the same expert available?
We're parties, it's our decision of what expert we go and choose. Just as it's like the applicant.
Bit harder.
Can we change the date?
Are either of the parties contemplating a special meeting date that works for everybody?
Yeah.
Casey, how much notice, I guess 10 days to notice the hearing, but as far as scheduling chambers, how much, I know this room is used frequently. Are you able to kind of see available dates after?
Well, we would need to get it scheduled as soon as possible based on when Chambers is available.
Yeah. And do you have a list of available dates for us to consider?
No, we'd have to do some research on the calendar to see what dates it's already booked.
Maybe ask for the dates that.
So, and board's attorney can correct me if I'm wrong, but, right, if we were scheduling to a date certain, we wouldn't need to renotice it. But if we need to schedule it outside of, right, this meeting, then we can renotice it. We'll just pick a date that allows us to meet the notice requirements. We'll have to coordinate the schedules of the commission members as well, which I'm sure we can't do right this minute. So, that's something that Mr. Herman and I can get on, tomorrow in terms of identifying dates.
We appreciate you considering that.
Yeah.
I know it's difficult for everybody, but we would like to have a fair case. So that's really what I think it comes down to.
Yeah.
Other things are logistics, right? Like doing the right thing is more important, I think.
Agreed.
Is there a requirement that the rehearing be, or the continuance is 1 month from now versus 2 months from now? I understand there's precedent that it's been 1 month, but is there?
Yeah, there is not, provided there is assent from both parties to any date. That would be fine, any date within reason, of course. That would be acceptable.
For whatever it's
Typically
worth, I'm going to
request.
be in Colorado September 3rd.
Yeah, I mean, sounds like we might have multiple people not here that day. So we're going to try to figure out a date that works for at least most people. Important to be here.
If I may, I understand that concern. The law does provide that, say, one of you can't attend and an alternate sits in your spot. That's acceptable. The alternate just has to become familiar with the matter through the minutes.
Yeah.
Yeah, again, so I think we're
Does
willing
that
to
have to be-
attempt to schedule it, on an alternate date.
Does that have to be on the record through Kyle for some reason? Setting the date and everything?
I'm sorry.
I'm not speaking into the mic. I realized. You look so close to me. I was asking if Kyle would have to reiterate that and get that confirmed and recorded for us to be able to go forward with that approach about figuring out the date that works for both parties as well as some of the commissioners.
That should be on the record, yes.
Yeah, if both parties would like to propose alternate dates in lieu of September 3rd, our regular scheduled hearing, that could be coordinated with Casey. I don't want to sign you up for more work, but Casey Evans, who generally schedules these, and she will work to, I guess, try and confirm at least a minimum of attendance of 5 voting members, I believe is what is needed to hear a case. Again, with it being an irregular date potentially, our schedules, all of us are pretty busy. So we do have this date set aside for ourselves as commissioners.
Yeah. And again, our intent is to find a date, close to that September 3rd date, again, respectful of everyone's calendars and availability, so.
I think that'd be amenable if both parties agree. All right. Thank you both very much. With that, this brings our QJ hearing matters to a close. Thank you again. Best of luck. We do have a couple other items on our agenda. Pat, I don't know if you had a report for us or any items.
No report, thank you.
And Dave, our vice chair, is not here. In case I don't know if you have anything you want to say at the moment, but I think as most of you know, this is my last meeting with you all. This is it.
Oh, okay.
It has been a great pleasure to serve with those of you here and those that aren't. I appreciate all the encouragement over the last year or so as I've tried to figure out how to chair this commission.
You've done great.
I do believe we need to go ahead and vote, and I'd like to bring up our newest members if they would like to partake in voting for the new chair and vice chair. And I think this will serve as the elections for this calendar year. I think we had discussed internally about trying to do this just after Sir Walter Raleigh. So maybe next year, try to get closer to that cadence. I'm sorry that
Yeah.
I won't be.
I can chime in
able to
about
serve.
the timing, because when the new bylaws were approved earlier this year, it actually does say that the elections will happen in August annually or as soon thereafter as practical.
Yeah. I
So
think
this
there's
timing is perfect.
Yeah, great. Glad I'm not causing any issues on that. So with that, if you guys want to deliberate about nominations, I totally forget how we did this before, if it was just vocalized or if we did the silly kind of write a name and.
We did write it down, actually.
So, yeah.
Yeah, I think we did write it down after some discussion.
Okay.
Oh, yeah.
I think Brooke and Travia could do great.
I'm just sitting next to you.
What?
That doesn't
No.
mean anything.
You're both articulate, very considerate thinkers. And I don't think in the time I've served, there's been a lady in the chair, so I think we could rate that.
Oh, we can fix that problem
Yeah.
anyways. Yeah. So, just to be clear, are we discussing about the chair position, and Dave will continue to be the vice chair, or is that?
I didn't hear back
The
from
the
Dave
election
on
is
his
for the
presence.
chair annually in August for the chair and the vice chair.
Yeah.
So, you could re-elect the same person for a position if you wanted to.
Okay.
Or a different position.
Yeah. I did Dave would be chair. You did?
No, nice try.
No, I thought you said Dave wanted to be chair or something, yeah.
Are you up for it?
I am not up for it. Honestly, I think I mentioned this last time, because I am a president for another organization this year, and the second half of this is really where things pick up for that, so I just want to be respectful to both organizations to give my best, so I don't want to come into something and not deliver. So that's why I was I was asked last time too, and that's why I didn't take it on, because it wasn't good timing for me, yeah. Well, is there a volunteer leave?
We could do a nose goes kind of thing here.
All right, you're in, Dylan.
So Dave didn't want
I just didn't hear back from him. I didn't want to.
Okay, because I thought we talked about it last week, and Dave said, yeah,
Yeah,
I'm
and
good with
I
that.
wasn't able to make it, so I wasn't privy to that conversation. If that's the case, like,
Good with.
Are we allowed to elect Dave while he's not here?
Yeah, yeah.
why not?
Yeah, I know, right?
I mean,
He
That
did,
feels wrong.
Pretty sure.
he did say he was up for it.
Well, he said he'd be honored.
I mean, that's honorable.
I mean, I guess, Pat, chime in if you disagree, but if you, I mean, tonight's a great night to do it because there's so many of you
Everyone's
here.
here. Except Dave.
If you really felt strongly and you wanted to wait till the meeting in 2 weeks, you could. And Dave, as the vice chair, would sit in as the acting chair for that, for the election on that day. But
You'd be great.
it does seem great
I
that
feel like
there's so
you
many of you
help
here to vote.
I was going to say you.
No, I don't want to do it.
We have a lot of good candidates. I mean,
I
yeah.
think you should do it.
Vice chair?
Or chair.
I don't want to be chair.
Would you consider vice chair if Dave was chair? Yeah,
sure.
But I feel like you're
Okay.
so good at like making carefully articulating your thoughts.
That is putting way too much responsibility.
But we have,
Does anyone
we
else
have
want it?
interest
Yeah,
for
no,
a
that
vice
sounds
chair.
good.
Dylan,
I mean,
do you
whether
wanna
we
do
do
it?
that here,
I would be up to it. I do think I need to work on the articulate part, but, you know, that,
Don't get discouraged for that.
you know.
Could work on that by being vice chair.
That's fair. Throw me in the fire, see what happens, you know.
I think we have chair and a vice chair. I'm just kidding.
Dave did say, I feel like Dave did say he was up for it.
I feel like Dave would do a really
We
good job.
can just
I mean,
bring
he
it up next meeting.
isn't he like one of the most senior members of
Yeah.
the commission?
Yes.
Yeah.
We need his expertise.
Yeah.
Yeah.
Oh.
What's the, if Dave's like,
The opportunity to,
Yeah, how many terms is
Resign
even
this?
after
from the-
6 months, can he like
Is he
resign
on
from
the second
being
or
chair?
third?
I mean, you guys could choose to have an election again.
Yeah, okay.
Yeah,
For the 2 years.
So you only get 3.
for whatever reason,
So
if you
he's got a
needed
little
to.
bit of time, because I think I had one more term, like 2-year term.
Yeah. But, yeah.
I
Can we,
think-
can we really vote for Dave if he's not here? I guess that's the big question.
You don't see
I
why
don't,
not.
I don't think there's a rule that says you can't.
But he can decline. Okay, yeah. So, yeah, we can.
Just out here, just
True, true, yeah. Can we do that then and see if you'd accept to be the chair?
Without.
I've seen a reason not to, I mean.
What, I'm not hearing all the
Oh,
conversation.
she's wanting, asking if we could just elect Dave to be chair.
Yeah, just gotta
bumbling through my comments.
make a motion.
Yeah. Make a motion to nominate Dave as chair.
I make a motion to nominate Dave Toms
Correct.
as chair of the Design Review Commission.
Any seconds?
second.
Second.
Yeah.
All
We
right.
have multiple seconds.
What was it?
Who's
Chris,
second?
seconded.
Oh, wait.
Oh, you second. Okay.
All right. All those in favor of electing Dave Toms as chair? of the Design- Aye. Any opposed? None?
Lesson learned, don't miss a meeting.
After saying you'd be honored.
That's right.
Do we have a nomination for vice chair?
Yeah.
I'll go for it. If no, do you want it?
Great.
Go for it.
Dylan, did you want to go for it too? We
I-
can vote.
I am indifferent.
I mean, we can vote, just,
Yeah, y'all can
wanna
vote.
have
Pick
the
your favorite of us
opportunity, that's
two.
all I'm-
I do want to mention that I think,
Oh, I might not.
John, I think you're technically still an alternate member.
Be okay.
That makes it easy for everybody, I
But-
guess.
But I think that, well, it's up to council, and they haven't decided yet, but I think you were on the list for the elevation to regular member to fill Kyle's vacancy at an upcoming
boy.
meeting.
Okay.
Assuming they vote to do that, of course.
Yeah, yeah.
So you wouldn't, I don't think you'd be eligible tonight,
That's fine.
but you'd be eligible after council, assuming council elevates you to a regular member.
Yeah,
What's
let's
council
wait
chance?
2 weeks on vice chair.
All right, yeah, sure. Do it.
Oh, Dylan. Great.
Yeah.
Or do we vote?
Oh, I guess y'all can
You
vote
want to?
too. Yeah, I can do it. That's fine.
Second.
Okay.
It's up to you guys.
I'll nominate Dylan for the vice chair.
I appreciate that.
I'll be, sorry, what's that? I do this for my board meetings all the time and I still
Is there-
can't do it.
Is there a second?
Yeah, is there a second, please?
A second.
All right. All those in favor of voting Dylan Davis to Vice Chair of the Design Review Commission?
Aye.
Aye.
Do I say aye also, or? Sure. Aye.
Vote for yourself.
Any opposed? No. All right.
Well, I think it's all about, right?
I think, Casey, unless you have any Sir Walter Raleigh updates, I'm sorry for missing the last meeting.
No, it'll hold until the next meeting. Just be prepared that at the meeting in 2 weeks, we'll have a lot of stuff to talk about, like programming-wise and speakers, who's going to be presenting the awards, that type of information. And just thank you for the folks that have reached out this week about the sponsorships and making those connections so that we can get that ball rolling for our communications team with the logos and everything. So thank you.
Finalized, right? Like for,
I'm sorry?
we have the band finalized, right, for
Yes.
the evening? Okay.
Yes.
just wanna make sure.
So yeah, just come prepared to talk Sir Walter in 2 weeks, please.
Thank you all very, very much.
Oh, we'll miss you, Kyle.
Do you want to officially adjourn the meeting?
Adjourned, please.